October 23rd, 2018, and I'd like to call to order this meeting of the Tennessee Board of Accountancy. This regularly scheduled meeting is taking place in room 1A of the Davy Crockett Tower at 500 James Robertson Parkway in Nashville, Tennessee. The meeting date, time, and location have been properly noticed, and copies of the agenda were posted to the Board of Accountancy website on October 16th, 2018. I'm going to ask Wendy to call the roll, and we'll determine that a quorum is present. So, Wendy?
AC Stewart.
Present.
Stephen Eldridge.
Here.
Gay Moon.
Here.
Andy Bonner. Here. Janet Booker Davis.
Here.
Pamela Church.
Here.
Larry Elmore.
Here.
Kevin Monroe. Trey Watkins.
Here.
Judy Weatherby. Here. And Gabe is not present at the moment. Here. Mr. Chairman, you have a quorum.
Okay, I'd like to make the announcement that Governor Bill Haslam has reappointed Gabe Roberts to serve as the board's attorney member. That's reappointed, and the appointment is effective immediately and runs through June 30, 2021. And I see Gabe has just shown up in the back of the room, and say congratulations to you, Gabe, and thank you for your service the past 3 years. So I know you'll do a good job the next 3. I would like to remind everyone when you speak to speak into the microphone so that your comments can be properly recorded. So that in mind, I believe everyone has been previously furnished a copy of the minutes. I would ask if they're, well, let me back up 1 minute. We need to actually approve the agenda for today. You have been furnished a copy of the agenda, and I would ask, are there any additions or deletions to the agenda? If not, I'll entertain a motion that we approve the agenda as presented.
So moved.
Have a second?
Second.
Any discussion? All in favor say aye.
Aye.
Any opposed? Okay, the agenda has been approved. Now we'll go to the minutes, and again, I think everybody's had a chance to review those. If anybody needs some time in the meeting this morning, speak up, but if you don't, I will just ask, are there any changes, corrections, additions, deletions to those minutes? Hearing none, I'll entertain a motion that the minutes be approved as presented.
So moved. Second.
Okay, motion is second. Any discussion? Hearing none, all in favor of approving the minutes, say aye.
Aye.
Any opposed? Okay, the minutes have been approved, and I think will sign those, and I think our secretary will sign those too. So. We'll go to the director's report, and I know you covered this briefly yesterday, but would you perhaps make some comments this morning, Wendy?
Sure. And first, before I get into that, just want to thank the board members who were wearing their pink today in honor of Breast Cancer Awareness Month. And for the record, Stephen did have his pink on yesterday, so make sure we noted that. But anyway, I appreciate it, and I'll move into the director's report. Future meeting dates I have up there at the top of the director's report. For the October 2019 date that we approved at the last meeting, we have a room conflict, so there's no room for us. This room is booked, so we need to come up with a new date. And so I proposed a little bit later that week. Thursday, October 24th would be the board meeting date, with Wednesday being the committee meeting date. Friday was booked. Really, this is our only option after the 15th, and not to conflict with NASBA's annual meeting. There are not very many options. So, and then I've also proposed a January 2020 date. So once we get to the end of this, we can vote to approve those dates if the board is in agreement with those.
So we need a motion right now to approve those dates that
Sure, if you want to, because there's nothing else to vote on in the director's report. So if we're comfortable with those, we can go ahead and vote.
I'll entertain a motion to approve the dates that, again, would you restate those dates for us? Just to
So the new date for October 2019 would be Thursday, October 24th, 2019, for the board meeting, with the committee meeting happening on Wednesday, the 23rd. And then also, I'm proposing January of 2020. That board meeting date would go back to Tuesday, January 28th, with the committee meetings on Monday, the 27th.
I'll entertain a motion that we approve those dates as Wendy has read them.
So moved.
Second.
Okay, motion is second. Any discussion? All in favor of those dates, say aye.
Aye.
Any opposed? So we have approved those dates. Wendy, and you have some other comments from your report?
Sure. With regard to NASBA activities, just wanted to congratulate Andy. He has been nominated to serve as a regional director on NASBA's board. That official vote will take place at the annual meeting next week. He will be kind of filling the role that Casey has served for the past year, so we certainly like to see that representation for Tennessee at the national level. I had, and I know that committee appointments went out this week. Some of you had sent me your letters where you had been approved for various committees. I think, Judy, you are on Finance and Administration now. Larry is going to continue on the Audit Committee, correct? Janet, did you volunteer for anything?
I'm on the ERB committee.
Okay, Examination Review Board.
Yeah.
Okay, so
yeah.
Janet will be serving there, and then I'll be serving on the Compliance Assurance Committee and the role and the Executive Director.
Wendy, I was named to CBT. I just neglected to send that to you.
Okay, great.
Wendy, I would also like to mention that I think Andy will be chairing the ALD CPA Verify Committee as part of his role on the board. So,
Yes.
So we got quite an involvement now, particularly compared to where it was a couple of years ago, and I just think that's good. I really do. So
I do too.
yeah.
It's great. Of course, NASBA's annual meeting will be next week in Scottsdale, Arizona, and Casey, Andy, and Janet and I will be attending that meeting. Executive Director and Legal Conference is in March next year in San Antonio. Legal staff and Sherry will be attending that meeting with me. There was federal legislation filed a couple of months ago to protect boards from antitrust damages. So I've listed that bill there if you all would like to try to follow that. It's still very early on and just in the initial committee phases, but the purpose of the legislation is to address the antitrust law implications for state professional and occupational licensing boards that were affected by the Supreme Court's 2015 decision in the North Carolina Dental Board case versus the FTC. So something just to keep an eye on. I'll keep you all up to date as that moves along. Regional Directors Focus Questions. We receive these questions, I believe, once a quarter. And we answer them, and it's our way of submitting information to NASBA's board, who reviews those. They typically, the request and deadline to submit doesn't usually correspond with our board meetings. So Casey and I, in the past, have been discussing these and submitting responses. I think what I might do in the future is go ahead and forward those questions to all of you, and feel free to send me your individual responses back. And the reason I say that, I think on this particular one, there were some questions about any universities and what type of changes they were making in their programs related to data analytics. And of course, I don't know a lot of that information, but some of you serve on advisory boards and may have had some more information that would have been helpful with that question. So when you see those in the future, feel free to get back to me. And attachment 1 has the questions and answers that we submitted this time around. Regarding the exam, on October 1st, additional testing sites were opened in England, Germany, Ireland, and Scotland, so more opportunities for individuals to take the exam internationally. CPE Tracker and Audit Tool, I talked about this yesterday. It is set to NASBA's improved platform for licensees as well as board staff to conduct CPE audits. Will be launched in March of 19. So we've had a chance to look at it. TSCPA also had a chance to look at it, and of course, I mentioned yesterday, I'm encouraging them to feed their data attendance records into that system to help licensees report that information easily. So we should hear something from them in the next couple weeks on whether they want to move forward with that. Communications, our fall newsletter is in the process of final approval to go, so it should go out in the next couple weeks. The contents in final approval, and then NASBA will have to lay it out and then distribute via email. Licensing and complaint metrics. This is something I have not provided you all in the past, but I see that other directors regularly report this, so I thought I probably should be. The attachment 2 shows all of the regulatory boards within the division, and it shows the number of applications that we have each month, or this is for September specifically, and the number of applications and then how many days on average it takes us to issue a license. And so you can see in September of 17, we had 64 applications. In September, it took 3.78 days to issue that license. In September of 18, we had 60 applications in 6.78 days. I'll say that September of 17 was a little bit of an anomaly. We're not usually quite that low. We typically run somewhere between 6 and 11 days. And, you know, at any given time, we have 10 or 15 applications waiting because they didn't meet the experience requirement, or that we don't have the candidate file from NASBA yet, or something that prevents us from issuing that license. So the goal is always to be the same or better than we were in the prior year. So that's what we try to shoot for when it comes to licensing metrics. The second part of that attachment is our complaints statistics, and our goal there is to, I don't know if I'm saying this right, to the legal team, but to present to the board or authorize for formal hearing cases within 180 days of being received. Am I saying that correctly?
More or less. We actually have to take another step after we leave here and actually send out the settlement agreements, draft those, and that stops
That's
our clock.
Included in the 180 days.
That's what has to, yeah, that's the time stopper action.
Okay, so basically within 6 months from the time a complaint is filed till when we send out those documents, we have 180 days to do that, or 6 months to do that. So right now we are at 93% of our cases meet that benchmark. And of course we have a few every once in a while that we can't, need further investigation, or we're waiting on something that is important to that case. So our goal there, I believe, is it 87%?
I think it's
90. Okay, 90%. So we are meeting the goal with respect to that. Are there any questions about that before I go on, since I haven't?
I got a quick question.
Sure.
Is there a similar metric that we could use to track, to understand the cost back of legal services that the agency puts on us compared to other boards that use legal services? You know, issue always comes up during budget. I just wonder if there's a similar, shows relative amount of time spent on our investigations versus other boards, to see how that
I can
translates.
certainly look into that. We don't have something right
Okay.
now. Obviously, I see what our legal costs are, and when I have questions, they give me more information, or what they can give me, but I've never seen it in relation to another board.
Gotcha. Okay.
Okay, so any further questions about that? Okay. TSCPA activities, I attended the Evaluation Chapter meeting on September 18th, gave a short update on board activities. Andy was at that meeting. So I will continue to go to the various TSCPA chapters and do the same thing. Sherry participated in TSCPA's Discover Accounting program at ETSU on October 1st in conjunction with a few other things she was doing for investigations. So it was a good opportunity for her to participate that and share the opportunities in the profession as well as in state government for CPAs. New licenses issued. You will see there that in the current year, we're at 462 for the current year. I suspect we will end somewhere below our 2016 totals, but above our 2017. So I think we're inching back up to closer to 700 total for the year. So we'll see how that ends up. Total licensing population is on the last page there, and it just continues to show that we inch upwards in our active licenses. So September of this year, we have 11,225 active licensees versus 11,053 in September of last year. So we have a gain there. And that's all I have, Mr. Chairman.
All right, well, thank you. Next item on our agenda is to review and approve the committee assignments, and you do have a list of those on your iPad. I'd just like to say thanks to everybody for your willingness to serve on these committees. I think most of you are serving on 2 committees. And would like to say particularly appreciate Larry Elmore, Gabe Moon, and Gabe Roberts agreeing to chair these committees again. So does anybody have any questions about the committee assignments as presented? I'd entertain a motion that we approve the committees as presented. And all right, got a motion. Do I have a second? Second. Okay. Any discussion of the motion? All in favor say aye.
Aye. Aye.
Any opposed? So we have approved the committees. Next item on our agenda is NASBA activities and committee reports, and I think Wendy had some comments about things that are going on at NASBA in her report that really are probably the more important things. But Larry, you're on the audit committee, I believe, or have been, and anything to report there?
Well, we just went through our busy season at the audit committee level because we had our annual meeting, live meeting in Nashville at NASBA's offices. Had previously been sent copies of the draft of the financial statements for NASBA, and were invited to critique those financials, ask questions, and put forth suggestions. And so then we had a meeting in Nashville to discuss those. Then we were sent copies of the MD&A to review and critique, and so those have now been sent back. And we're pretty much in the final stages of the audit, and I think it's probably going to be presented in final form at the annual meeting next week. So I'm continuing to enjoy that appointment because it's fun for me to be on the other side of the audit and be on the approving committee side as opposed to the presenting side. So it's a good committee, a very active committee. It's got some good involvement with it, so I'm enjoying it. But we're wrapping that up right now.
Janet, I know you were on the task force. You got something you?
No, there's nothing new on that task force. I mean, we've completed the work that we were assigned to do. But I was asked to be on the examination and review board, and I agreed to do that. And it's interesting. I'm learning a lot about what that board does, but basically that board is charged with reviewing and evaluating the policies related to the preparation of the exam, grading of it, and administration of the exam, and looking at NASBA, AICPA, and Prometric involvement in that process. And then a report is issued, and it's for the benefit of all the state boards of accountancy. And that report, I think, is generally gone over at the June regional meetings, I believe. So I've been through some orientation right now, and we're going to be doing some planning for field work and doing the audit procedures and getting that report ready for next year.
We really haven't had any additional calls on the ethics committee since our last board meeting, but since then, as Wendy mentioned, I'm rolling over to the administration and finance committee, where I'll be working with Jimmy Burks and Michael Bryant. This looks like a very interesting committee. I'm looking forward to doing that. They wanted to make sure they had a diversified group of people working on this on this committee, and I'm really looking forward to it.
Okay. I've been serving as chairman of the ALD CPA Verify Committee, and of course, as you know, the ALD part of that is restricted to our staff. I mean, as chairman of the committee, they wouldn't even let me in to see what was in there, but that's one that we use significantly, I think, Wendy, almost daily in doing our job. It's very helpful. The CPA Verify is the public-facing part of that application, and I mean, where you can go in and look up a CPA in another state. And the difference between the two, I think, is really the level and detail of disciplinary data that's in that non-public part of that database. So it's a very useful tool. We did have a conference call. We've met twice this year, both of them by conference call. Normally that committee meets face to face one time a year. We decided not to do that because the application is, we've done about all that we can do with it until the system is rebuilt. And I mean, they're going to have to reprogram it, and they've got it on the agenda. The money has just not been there yet. Some other things have had priority, but I think it's moving up on the priority list, and they will rebuild that system and make it even better, I think, and more useful than it is now. It's just a matter we can't do much until they do that. Of course, the board meeting in July, that was pretty much business as usual. I mean, review and approval of minutes, review of financial information year to date, a list of people that will be receiving awards at the annual meeting, a report from the nominating committee. I mean, just a lot of things like that. The one thing that and going back and looking at the minutes of that meeting, the task force that Janet served on, we did have a report there that basically said we really, really appreciated the response of the AICPA, and I think they made that response in a verbal presentation at the regional meetings. I know I was at the East regional meeting. Andy, I think you went to the West. But the AICPA took very seriously the questions that were raised, the concerns, and I think we felt like they responded in an appropriate manner, and so that was probably the biggest thing in that meeting, other than just the normal business. That's pretty much it. I will be going out right before the annual meeting for my final board meeting. This will be my last one, and then Andy will be serving in that role after that. But it's been a great experience. I did not resubmit my name to be reappointed, and the reason for that, I know some of you know I've got some back issues, and they come and go, and when I sit in meetings like that for 4 or 5 days in a hard chair, buddy, it's a hard trip home and a couple of weeks of hard work to get back to where I can function. So I just felt it was best for me and best for NASBA if I don't continue to serve, and I think Andy will do a fantastic job, in that role. So, anyway, that pretty much concludes my report. Did I miss anybody that's had any NASBA involvement? Again, Janet, I know you've been the audit committee. That's not a lot of work, so I don't. But I'm glad you're enjoying sitting on the other side of the table, though. So, but that's pretty much, I think, the reports from NASBA. And does anybody have any questions about anything that I said, or any other concerns or issues about NASBA? And I mean, I just. In serving this last year in particular, I think they are true to their mission. I think they really want to enhance the effectiveness of the state boards. They want to make our board more effective. I tell you, go to these meetings and you see how different every state is. I mean, in terms of the number of the members on the boards, some have 7, some have fewer than that. We have 11. I mean, just the number of people involved on the board, the number of times per year they meet. Some boards meet monthly, unless they don't have any kind of announce if they don't have an agenda for a month, they don't meet, but otherwise they meet monthly. Some of meeting times, different regulations. I mean, while we've got the Uniform Accountancy Act, you go to CPE, I mean, it became obvious in the Eastern Regional meeting as we went around the table, some boards require 40 hours annually. Some are like us that have 80 hours, biannually. Some have 120 hours every 3 years. Some have a technical requirement, some don't. Trey, I know you've raised the issue in the past about reciprocity with Florida, and one of their problems is, and you could talk to the chairman of the board down there. He says they are awful on CPE, and they've tried to get it changed and get more in step with the Uniform Accountancy Act, but they have board members that just insist that their ethics requirement be strictly Florida driven ethics, and so. It's just different, and to get the states to change, you can see how long it takes us to get a rule or a statute change. It's just a long, laborious process for every state. So we are moving in the right direction. I think NASBA is helping to facilitate that. It's just slow, and anyway, I think they really try hard and do the best job they can of moving us. Okay, I'll get off my soapbox on that because we got the board and committee reports, and Larry, I believe you're first with licensing. And
okay. Yesterday at committee, the licensing committee addressed 3 issues. The first of which was we had an applicant who was requesting reclassification of some credits she had taken at South College, where the college had classified these courses as something other than upper level. And so in discussion, at lengthy discussion yesterday, we looked at the communication that NASBA had given her. We looked at communication that another university, I believe it was Strayer, who had approved those courses for transfer if she had done that. And after discussion and considering all the facts, the committee would like to recommend that to the board that we approve those classes as upper level. In this case only, due to the fact that NASBA had provided her with a letter prior to the rule change that said that the classes she had taken all qualified for upper level classification. But we'd like to approve this with the stipulation that the board staff would communicate to colleges and universities in Tennessee about the importance of making sure they to them or to instruct them that it's very important how they classify these courses, because it is important to the board and in helping them decide whether they classify or qualify as upper level classes. So the recommendation for approval is accompanied by a request for the staff to communicate that to colleges across the state. And I'm sure Karen had a heck of a time trying to follow me on that. So let me say it again. The recommendation that we would like for the board to consider is that we approve Ms. Kerrigan's request to classify these classes as, these 3 classes that she submitted to us, to qualify them as upper level classes, in this case only because of the extenuating circumstances that existed in this case. Primarily because NASBA had provided her with a letter previously that approved those courses as upper level prior to the change in the law. And that the board, and that our recommendation also includes a recommendation that the board communicate to colleges and universities across the state about the importance of how they classify their courses as upper level or lower level.
Want to make that in form of a motion?
Yes, that's a motion from our committee, yes.
I'll second that.
Okay, we got a motion, a second. Is there any discussion of this issue? Hearing none, all in favor of the motion say aye.
Aye.
Any opposed? Okay, motion is approved.
A couple other issues on our agenda yesterday. Wendy covered some state-specific ethics updates and a review of the course outline related to the ethics course. And I think one thing that came out of that was that we authorized or recommended to staff that they develop a required versus optional classification on the various parts of the course. Due to the comprehensive nature of this course, it's hard to cover all of the things in the course outline, depending on how long that course is, whether it's a 1 hour, 2 hour, or 3 hour level course. So we, after discussing the outline and talking about the various parts of the outline, we recommend that staff develop a required versus optional classification for those parts of the course itself.
We need to approve that outline, do we not, Wendy?
Yes.
So, again, do you want to make that?
Yeah, we like the outline, just have that recommendation that we'd like to accompany with the, but I recommend approval of the outline as currently submitted.
Second.
I'm sorry. Go ahead. Sorry. Go ahead. There'll be discussion. Go ahead.
We'll take that as a motion on behalf of your committee, and do we have a second?
Second.
Second. Okay, any discussion of this issue?
Just a quick question on that. So we're going to now alter this for required and non-required, right?
So the way that I am interpreting that is that
I'm just saying, the only thing I'm asking is we're approving a outline right now for which we're about to say change it. So I just want to highlight that. Or are we just granting you the authority to approve I guess we have to approve the outline.
I think you approve the outline, and these items should be included in the course.
But not all of these, right? Because you're saying that some of these may not be called.
So what happened in the current course was there was a lot of theory. There were a lot of discussions about what's ethics, what's not ethics.
Okay, so this outline does not contain that information.
Right. So
you've already made those changes, is what you're telling us.
So what I'm asking to approve here is a slight change in the outline, and then once they've created the course, I will go through it with them and say this slide is on the outline, so it has to be included. This slide isn't on the outline, so you don't need to include it.
You're just making their outline match our outline.
Correct.
Okay, I'm good.
Okay, any further discussion?
There were some changes already highlighted on her outline
right.
that we talked about yesterday.
They were including some things that were outside of the outline. And so to the benefit of the presenters like Doug Warren or Perry, to make sure they know which things they have to cover and which things are optional that are outside of the outline. Because they don't get to see the outline, the presenters don't. I mean, they only see the content once it's finalized.
They could see this.
They could if they asked, but I don't think it's part of what is
They would
supplied to
normally
them.
get. They're paying for it. They're getting whatever the finished product is.
Yeah.
Okay.
Okay, any further questions or discussion? If not, all in favor of the motion, say aye.
Aye.
Any opposed? Okay, Larry.
The third item we discussed at our committee yesterday was the CPE compliance. Wendy had provided us with a 2018 state-specific ethics overview, kind of update on how that course is going, some of the sponsors currently providing it, some of the comments that we've received, talking about the memorandum of understanding was attached and so forth with the TSCPA, and that just had a really good discussion about the course and how it's going. And as part of that discussion, we talked about another thing that Wendy had submitted to us was a list of recommendations titled CPE compliance recommendations that would further improve and change the way that our board would ask applicants to submit their annual or biannual renewals, including a detailed analysis of the courses that were taken as opposed to just checking a box and saying I did comply with the requirements. So as a part of our discussion, we recommend that we authorize Wendy to proceed with those changes to the CPE compliance requirements as shown on the submission that she provided us yesterday. So I'll make that in the form of a motion.
Have a motion. Is there a second?
Second.
Okay, I've got a motion and a second. Any further discussion of the motion?
I wanted to just thought about this a little more last night, and I know there are other boards that have CPE requirements and that sort of thing. I was wondering, I don't know, I mean, there aren't that many boards, but boards that we do have that require CPE, if we could find out possibly if they have a box that says yes or no, or if they, I believe they have to literally upload their certificates and whatnot.
Kind of did that yesterday, didn't you?
You mean like for the real estate commission, for
or
other
physical therapy, or any boards such as that. They all. I mean, we're moving toward that.
Right.
But I think, and I know that it's going to be a cumbersome thing for our CPAs to do, but I don't think it's out of the ordinary. Okay, I think it's pretty much required by all boards that they have to submit information as to what courses they've taken with proof that they've taken them and all. And I just think given the high audit with our audit results with people not complying, I really think we need to move to that sooner than later. And I think we would find if you did research that a little bit, that this is not out of the norm, that it's actually required by most other boards for people who have required CPE. So
I'm about going to the next level and requiring
state medical board or somebody like that, where they're having to get.
Yeah, I think it's.
But are you
it's a requirement.
suggesting that we actually submit the documentation of the classes with the renewal?
I think most of them do that, and I think we should move in that direction.
Type in the actual,
I do. I mean, we have such a high rate of noncompliance. I think we've got to do as much as we can to move toward that. I mean, we were second to Missouri on that quick poll with 30% of noncompliance of 10% of
In Missouri was
CPAs
49. I couldn't get over that.
every other person.
Yeah.
Something's wrong. I hope.
I mean,
That's why I think the answers to the questions, you kind of have to, some of them seem a little off, so maybe they didn't understand what we were asking, or,
Is there a licensing committee? I'm sorry. Maybe we should do the vote and we can talk after. Should we just?
okay, yeah.
I'm sorry.
Was Judy, are you recommending?
I was
that-
just asking if Wendy could possibly just reach out to the other boards and see what they require for CPE on their renewals and their submissions.
And I would take into consideration with the nanotechnology or the learning CPE, you've got quarter hour here. I mean, I'm curious. I mean, in our firm, we have a lot of 1 hour webinars. That's a lot of certificates to upload. I'm just wondering if a lot of that's a.
I think you can drive that direction. My point is, I think if you start listing the classes at a minimum and start there, let's see how our audit results turn out.
Yep.
And if we need to
agree.
morph beyond that, we can't. We can do that.
It's too easy just to check that box and say, yes, I complied.
Right.
Mississippi, you just type it in. You don't have to submit all the certificates unless you get audited.
I agree with the
I would like
listing. We used to have to do that, but I'm just worried if we do the upload and
the
you've
actual
got
certificate
of
or
the
whatever.
Well, and we may be moving. I mean, she's been talking about this program that NASBA's been developing, that if they eventually do move onto that platform, it will be unnecessary to
Right.
upload.
We
I
can,
agree.
I think at that point, we'll just use that database and everyone will be audited, 100%, if NASBA's platform gets implemented and works properly.
And then, because the ultimate goal of that, we're talking to TSCPA about them feeding over their attendance records, but the ultimate goal is that any vendor would be able to feed over their attendance records, and then there is no certificate any longer, really. So I'd like to see how the listing works first, and kind of evaluate what our compliance rate looks like after that. Plus, I think we're going to get to a point where a lot of that is, a majority of the CPE is already in the system.
Is there a licensing committee at NASBA, or where does that fall in the NASBA spectrum?
Don't recall that there is.
I think what was telling to me
Marie
yesterday was the statistics that you provided. Again, whether people didn't, what it did highlight to me was that there is a high level of failure across the board. And with all these committees that NASBA has, this seems to me to be one of those areas for which I would think they'd be looking at this across all state board levels. I mean, I don't know. That was scary to me yesterday, and here we are talking about our professionalism, our standards, and the level we hold ourselves to, and we've got these levels of failure.
Yeah, I agree.
And
I
that's
think
disturbing.
That's my concern as
the,
well.
the other thing that we talked about yesterday that I thought was relevant was that, and we'll see in the enforcement report, several cases where the respondents indicated that they actually, when they filed their application for renewal, checked that they did not comply with the CPE requirements, and basically our past policy has been, well, we'll flag them for audit and deal with it later, versus stopping that process now and saying we're not going to renew you until you can indicate affirmatively that you did comply. And I
It
think
just
that's
seems to me there were
important.
so many people doing it so many different ways
Yeah.
in each of the states, and some don't even have audit. I mean,
Right, some
which
aren't
was
even
even
right.
crazier to me.
Yeah.
But there's no uniformity, is what I'm saying, across all state board levels. Maybe something y'all could highlight at the state. I mean, at the NASBA level. I don't know.
I think with the project NASBA's putting together, that the goal is to get there, based on what I've talked to some of the staff there. Is
I would
that
definitely show them
with this
whatever
project,
whatever
yeah,
Wendy presented
yeah,
to us yesterday.
yeah.
I would show that to them because that highlights to me a
And I
huge
think what
problem.
we're doing is a good first step just to make sure the technology works. Because I know right now the technology is horrible. It's too cumbersome. It takes too much time to go in and put your CPE in there. But I'm looking forward to the new software in March, where you can go in and especially if they get everybody to upload, that's a game changer. And then we could automatically that would be such a benefit for all the boards across the United States and the provinces that it would be a game changer.
Yeah, like, I think it was when I first came on, I was very surprised about that it was just a box that you checked, and we only audited 10%, and there was a lot of we saw a lot of legal cases, and I think I talked with Wendy and some people at NASBA about at this day and time with our technology, that should not be the case. And then they abandoned one platform and now have started this, or have getting close to the end of this one. So I'm very excited to see the progression since a couple of years ago.
When y'all discuss it too, hopefully they'll take into consideration that it'll play nice with the bigger, like Checkpoint Learning or the other bigger tracking programs, which I assume it will. But that would be, I think your success rate would be a lot better if that's the case.
Is the NASBA program that's currently being developed or being improved, does it put more of the responsibility on the provider?
Yes.
To provide the information on who attended and so forth?
So initially, they are really looking to get all state societies to participate first. And if that goes smoothly, they will open it up to other vendors. I don't believe right off the bat that other vendors will have the opportunity to kind of on a nightly feed push stuff in there. They may be able to do it manually. I still am a little bit unclear. But the goal is to get there. Once
that would be the ideal situation, just to have a database that the providers would shoot information to, and that each person who has a license would have a record of all the classes they attended. That is, the information is input from the providers.
And even they'll have a routine. Even let's say, Larry, your firm puts on something at the firm level, they would send you a routine where you would just input the data, and it would be fairly simple for you to even upload manually the data to the tracker.
It'll solve a lot of problems if we get that to work.
And ultimately, I think, the goal, which I've already stated, but, it may be a condition of being on the registry at some point. If you're going to be on NASBA's registry, you'll have to upload your attendance record. So it may end up there in 5 years or so.
I just want to highlight that we're putting a burden of proof on our practitioners in the state of Tennessee, and there are other states that do not have as stringent of requirements. And the only thing I'm trying to highlight here is that if NASBA is looking at the issues, it would be nice if they would hold everybody to the same level of standard. That's all I'm pointing out.
That's true, but I do think that we as a board are called to protect the public. And to me, with that,
not arguing that point. All I'm saying is, if my practitioners here, or if we're holding them to that standard, I would hate for them to feel like they're getting slighted because other states don't require as much. Just saying, NASBA's there to create uniformity across all state boards. There's no reason they shouldn't be looking at this and stating, hey, everybody's doing something different. You're not requiring audit. You are. If we're trying to improve the profession and we're holding ours to a higher standard, I would hope that NASBA then would want to bring everybody else up to that standard. That's all I'm saying.
Casey, I think this is certainly something we can talk about in our Eastern group next week.
Yeah, and that breakout session's been expanded to 2 hours now rather than one. But I appreciate your comment, Trey. But what you'll find with NASBA is they talk about it in these breakout meetings or sessions where they do that. They're providing this CPE tool that's coming out in March, but they can't really make the individual states do anything.
They can encourage, like they have with the
UAA.
Yeah, and
there
should be
they do that, but
right.
When it comes right down to it, you have some states that say we're not going to do that, and they have to accept that. They're there to support the state.
The question is, have they done this in this regard?
Oh, yeah. I think they've been, and that's part of the thing on this new tool that's coming out in March. That thing was supposed to have been out like a year ago, but the vendor they hired to build the system just really totally botched things up, and they had to fire them and start all over again.
Right.
Or we would have had this a lot sooner. But fortunately, they got a lot of their money back. But they've spent a couple of $1 million developing this thing.
I think it's a great piece of software. Yeah. My point is, I hope they're trying to elevate the profession as opposed to saying it's too hard to not to do it.
Yeah.
And so I think they need to. I would be hoping that we would be talking in the committees that we serve on about the fact that, hey, we're trying to hold our practitioners to a high standard. It would be good for the profession if everybody did so.
Yeah.
Because yesterday's chart that she showed us showed how varying the degrees are between each of the state boards.
Yeah. And we appreciate your feedback, and we'll bring that up in this breakout session.
Right.
It's one of the things we're really concerned about.
Because I mean, she got those stats, right? Those didn't come from NASBA.
Right. I mean, we used NASBA's to facilitate, but I don't know that they do anything. You know, they just provide the data to me. I
Right.
don't think they do anything with it.
To me, it's just a good uniformity thing.
Yeah.
And I would just, for our board, I'd rather be one of those states that's setting the higher standard
Agreed.
than coming in later to comply with the standard that another state board set. And I realize it's harder on the practitioner, but it also better protects the public. And
California, I can see it.
yeah. Anyway.
So can you clarify one thing for me? So the society can set their own, they can approve their own CPE. The AICPA can, right? They don't have to go through, NASBA approves CPE.
So AICPA happens to be on the registry. They don't necessarily have to be under our rules. And
Right.
you're correct. The society is considered an exempt sponsor. They don't have to register with NASBA.
So how many organizations are on that registry?
On the registry, for
Yeah.
NASBA's registry?
Well, not NASBA. If NASBA's the one approving, I guess they grant the authority to those societies. NASBA's the ultimate decider. Is that correct?
So,
Besides the state boards.
right. So our primary rule is that any provider of CPE has to be on the NASBA registry.
Do we know how that exists across the spectrum of other boards?
A lot of states have an option to approve their own CPE outside of that.
Which we do too.
We do, but we're actually fairly limited, meaning you have to be an exempt sponsor or a firm or employer providing something without charge. So we're a little more specific. Some states allow.
My only point is that
Somebody
when
just-
NASBA approves some CPE, I don't know why it doesn't get like a standard numbering system.
They do.
They do.
They have a number.
So then my question would be, is if we do ask people to put classes in, you would think at some point you get to the point where you had a drop-down menu.
Well, there's
If this is class
thousands.
1005,
There's thousands of people in there.
but they're having to look at each one
Right.
of them.
Right.
Shouldn't be that big of a deal to go in and key it into a master database.
Well, you do outside of that have TSCPA, you have firms
I get
providing.
it. I get that there's other ones,
Yeah.
but if it's only a few organizations, that's different than if it was 10,000 organizations.
Right. I don't recall exactly how that platform works. It looked great when we saw it, but
Right.
with seeing it one afternoon in screenshots, I don't remember exactly how it works. If you
We're
enter
off
the
topic
number,
here. I'm sorry. I just
If you look
Let's
at your
go back to
CPE
those.
certificate, you actually have the NASBA number of that provider
Okay.
on it, and so then it's
I just don't think I've ever noticed it.
yeah, it's mandatory. It's on there.
Because you would think if they're doing that, if they're putting it on a certificate and they're doing all this stuff and communicating with them, be like, why do you not have a standard list of all the ones you've approved?
I think once it's finished, that you'll see that it'll be more robust and they'll have other options than what we currently have.
Okay.
A motion and a second.
We've got a motion and a second. Is there any further discussion? Okay, all in favor of the motion say aye.
Aye.
Any opposed? The motion carries. Anything else, Larry?
No, that's all our committee has.
Okay. We will go to the Enforcement Committee, and Gabe, I just note that Kevin did a very good job yesterday filling in for you, but if you'd like to make the report,
I was about to say, I figured out it would be a coup as soon as somebody else got to do it. That's awesome. It looks like there were no changes, too. Now, if it's okay, Mr. Chairman, I think Mr. Elmore should, Mr. Monroe should do it.
Okay.
Politely saying.
Yeah.
Good luck, Kevin.
All right.
You may proceed.
Okay, thank you. And what I would propose that we do is similar to the order that we discussed it at in committee. We'll take the items on the consent agenda first, which were items numbers 1 through 18, and deal with a vote on those. Then we'll move to the items 19 through 35, and then we'll address 36, which is the representation. And before we get to 36, if we could just double check, I saw that the new version passed out, but I think we did change that recommendation.
That's right. That
So-
was the only change as far as recommendation from a 3-year suspension to revocation.
Okay, so we'll cover that when we get to that, but I wanted to make sure you were aware of that change. So the one other note that I would say as we begin, yesterday we discussed that there were several common themes in our disciplinary findings here that we're going to be asked to evaluate and vote on. Again, failure to obtain peer review, and I'm highlighting these for the masses of Tennessee CPAs that are likely avidly watching this webcast. Failure to obtain peer review and doing attestation work. Failure to obtain the necessary CPE while your permit or license is active, assuming that just because you're not doing anything and you still have an active license, you don't need to worry about CPE. And then holding out as a CPA or using improper terms in your business name or in your other facets of your business. So let's take the consent agenda items 1 through 18. The committee had a chance to review these in detail in the publicly held committee meeting yesterday. And so at this point, I would just open it up to the board members if there are any questions or comments on a particular item number in the consent agenda that you want to pull out for separate discussion. If so, we'll discuss it, and if not, we'll go ahead and move to approve the consent agenda items in one motion.
We'll entertain a motion, so.
I'll make a motion to approve 1 through 18 on the consent.
Okay?
I'll second.
Motion and a second.
I'll second.
Okay, thank you.
Okay, any discussion of items 1 through 18? Hearing none, all in favor of approving the recommended disposition of those, say aye.
Aye.
Any opposed?
Thank you. And now moving to the second of the three batches or tranches, the recommended discipline, which is items numbers 19 through 35. Again, the committee had an opportunity to review and discuss and briefly summarize each of these cases yesterday. In all of these cases, the committee voted to recommend the stated recommendation for the board's approval and consideration this morning. And so again, if anyone has a particular item in this batch they'd like to call out for particular discussion, we'll certainly do that. And then if not, then we'll entertain a motion to approve the recommendations for each of these items in disciplinary cases numbers 19 through 35.
Kevin, which one was it we changed the suspension to?
That was number 36 on the representation, so we'll get to that separately.
Do you want to make that in the form of a motion then?
I would move that we recommend or that we approve the recommended disciplinary recommendations here for items in cases 19 through 35.
Second.
Got a motion and a second. Is there any discussion? Hearing none, all in favor of the motion, say aye.
Aye.
Any opposed? Okay, Kevin, that's good. We've got those approved.
One more to go. This was the representation, and this was the subject. This was the one item where the committee did suggest or recommend a change in the staff recommendation for discipline here. And the gist of this case was that we had a complainant that was filed, a complaint filed against the respondent, and the respondent was charged with 2 Class 2 felonies in Pennsylvania. So this is really arising from, I guess, parallel discipline that we have to look after given our situation. That respondent did not, as required, notify the Tennessee board of that disciplinary occurrence in Pennsylvania. It should have been done in terms of in writing within 30 days of his conviction of a felony. And so that did not take place. And so the original recommendation was for a formal hearing for suspension of the CPA license and authority to settle by a consent order for suspension of license until the ARD program, which is this Pennsylvania rehabilitative program, is completed. That was scheduled in May of 2021. After a fair amount of discussion and deliberation, the committee voted to modify that recommendation to recommend revocation of this person's license in Tennessee. He was licensed in Pennsylvania and in Tennessee. So the committee's recommendation is to recommend revocation, and at the point that the person wishes to try to reinstate his license, if ever, then we'll go through our statutory process with respect to that. And so that was the recommendation of the committee in this particular case. And with that, I'll open it up for any comment or discussion.
I make the motion that we approve the recommendation to revoke.
I'll second.
Already got a motion and a second. Now, is there any discussion of this case or the recommended decision? Okay, hearing none, we'll ask all in favor, say aye.
Aye.
Any opposed? Fantastic, Kevin.
Welcome, but I fully acknowledge I'm not worthy to carry Gabe's sandals in these matters.
You probably wouldn't want to.
Certainly burden him the next meeting. So,
Gabe can carry 5 sets of sand.
That's right.
all right. Thank you. Law and rules, yay.
Mr. Chairman, Liz provided us an update on pending and newly effective rules that have been passed, being the names, CPA firm names, as well as our CPE coursework. Then we had a discussion of the NASBA's and AICPA's and Prometrics studies of a continuous testing for the exam as opposed to using the windows. And then lastly, we discussed the Texas survey and rule change concerning the entrance of data analytic coursework into the college curriculums as it relates to accounting. We didn't have any kind of recommendations, just those discussions yesterday.
Thank you. That takes us to the executive committee, and we had 4 items that were on our agenda yesterday. Review of the fiscal year 18 closing and fiscal year 19 financial results, and I thought it was just me, but I could not find that on my iPad yesterday, but I understand it was not on anyone's iPad. So Wendy or someone has handed out hard copies of that to everyone. I did get the information when Wendy sent out the advanced materials, so I had a chance to see it. So I don't see any need to go back through Wendy's comments. I think everyone was present yesterday when she covered that, and so unless somebody has questions or wants to bring something up, we'll just move on. And
Gabe, I know Gabe wasn't available yesterday. Did you have any questions on Wendy's? Okay.
The next item was travel, and that report again was on our iPad. We looked at it yesterday. It was nothing really of significance there. The next item was the fiscal year 20 budget proposal. Wendy did go through that in detail, including her supporting schedules, and supplemented that with verbal comments. I do not see a need to repeat that today, so I would just like to make a motion on behalf of the Executive Committee that we approve the fiscal year 20 budget as presented.
I'll second that.
Got a motion and a second, then. Now, is there any discussion? And Gabe, I'm assuming you had a chance to review some of this stuff in the advanced materials, so any questions or comments? Okay, all in favor of approving the fiscal year 20 budget as presented, say aye.
Aye.
Any opposed? And the last item on our agenda was the CPOS contract renewal, which Wendy made a verbal report. We don't really need to take any action on that. I think it's just keeping us up to date on what should happen and needs to happen going forward, and also the fact that we will be undergoing sunset review, I guess, next year. But there will be an audit process that will take place, either limited or full audit prior to that sunset review. And Wendy, I'd just like to ask one thing there. The last, I guess, audit that we underwent, the peer review oversight, was the one issue that came up, wasn't it? That they basically.
So the one comment that we received was that the board was really unable to regulate the quality of practice and protect the public because they didn't have a peer review oversight committee and because we did not have access to the peer review documents or the results of peer review. Now, the recommendation was to consider making statutory changes to obtain results of peer review, which we've done that piece of it. With regard to the oversight piece, I I'm patiently waiting on the UAA to release their revised peer review rules. But I'd like to make some changes to the rules to make it easier for us to develop a PROC that's effective. And so that it's not that we're not going to do anything, it's that we're kind of waiting to do it the right way.
What happens if we don't have something in place by the time the next sunset?
Well,
Will they not revisit the findings from the previous audit?
I think the fact that legislative changes were made and that we can show that we are actively keeping up with firms that are to make sure they're meeting the requirements. Now, the one thing we haven't done, which we briefly discussed, but are we going to take action against firms that have successive fail peer reviews? Are we going to open complaints? Are we going to take any action from a disciplinary standpoint or look into those matters when firms don't
If they repetitively fail, aren't they kicked out of peer review?
If they what?
Or if they actively fail, they're kicked out of peer review at some point.
Not always. So you fail one and you get a warning. If you fail your second one, then you're eligible to be kicked out. You do have to go through a hearing process, and they can convince.
But not with us.
Not with us.
Right.
With the administering entity, correct. And then we would be notified if they were kicked out of the program. So right now that's what we're doing. That's the only tool that we're using to discipline somebody is if you're kicked out of the program for either failing your peer reviews multiple times or other reasons, that's when we take action currently.
My question is this. If the administering entity doesn't kick them out of the program after multiple failures, I guess my question is can we really kick them out? Because all we tell people in the rules, isn't it, that they have to be enrolled in peer review?
Correct, but what you could decide is that failing peer reviews multiple times mean you're not following professional standards, and that's a matter.
Seems to me we'd be coming down on the administering entity and not necessarily on that individual. I don't know. I'm kind of seeing this differently. I don't know. I would say that if somebody has multiple back-to-back, we need to have oversight over the administering entity. I mean, yes, we have authority over individual practitioners, but we have granted that authority to the administering entity. Now, if that administering entity is not taking the approach or the line that we want them to take, I feel like that's our oversight on the process, right?
Which is what the peer review oversight committee, yes, would do. So the plan is to get there. It's difficult with our current rules because you're limited to who can serve. My
point is this: I don't want to go down the path of going after individual practitioners.
Okay.
And this is my opinion, so I'm not speaking for anybody on this board. Everybody may feel differently. If we start going down that path, then basically what we're saying is we don't trust the administering entity to administer the program. And that's where I think our oversight needs to be focused is what are the punishments at that level? Are they capable of handling it? And if they're not, and we feel like we've got to go individually sanction a practitioner because they're still in peer review, they're enrolled, I don't know. To me, that's a very dangerous path we're going because then all of a sudden we're undermining the administering entity's process. Does anybody? I don't know how everybody feels about that. I don't know.
Here's I think that although somebody may fail consecutive peer reviews, they take it very seriously when they kick someone out because they're basically restricting their right to practice to perform a test work because you have to be enrolled in peer review, correct?
Right.
So if you kick somebody out, you're effectively saying
you can't. You're out of business.
You can't. You're out of business, and I think they're not the regulator. So in some cases, they're going to kick them out because they've tried to remediate these firms and were unable to do so. In some other cases, they may not kick them out, and that may not have been the decision that you as a board would have wanted them to make because you're not, you don't like the work that they just have a different.
I guess my question then would be: are we not setting it up to where the society can say, "Hey, these are members of our society, and therefore we don't want to make those hard decisions, so we'll let the board deal with it at that point," and they can just kick the can down the road and not make one of their practitioners mad. I don't know.
It's
a very complicated issue,
I agree.
and I feel like it's incumbent upon the administering entity to be doing what we ask them to do, which is to administer the program. And if there's repetitive failure, then for whatever reason, I mean, if they let them stay in, I presume there's a good reason to let them stay in, not just a business reason.
No, I think that the firm has to justify they've made improvements or what. I don't know what the reasons could be, but I know it happens.
But then when they come before this board, my point is they're going to be presenting the same rationale, same reasoning. So then it becomes an issue of...
They've already violated our rules at that point. Meaning they've already performed work that's not in conformance with standards. So, you know, that's just
They shouldn't be in
something-
peer review then. I guess that's what I'm saying, is if they're not doing work in accordance with standards, how does our administering entity allow them to continue practicing?
Historically, we haven't had access to those peer review reports.
Now
and
we
so
do,
now
right?
going forward, we will. And I think we're going to have to need to adapt and consider, you know, exactly what you're saying, Trey, is now that we do and we have transparency into what those peer review reports are saying, is there enough of interest and concern to us as the regulator to take action? Should we be more affirmative in reaching out rather than waiting on the
Or
peer review?
should we just be telling the administering entity, if you have somebody with back-to-back failures, we need the rationale behind why you did not kick them out of the program?
Well, I'm not sure that information's available.
Well, but I mean, we're contracting with them to do this work, are we not?
Well, we are approving that program, but we're not contracting. That's the program we've approved, and not everything is available to us. There's still confidential nature. There's still confidential nature to everything that happens.
Let me ask, if ultimately we have concerns about the administering entity and we're not happy with them, we can select another administering entity, right? We don't have to use the...
Not the state society of Tennessee. We could use Mississippi.
Or Illinois, or
we
New
could use
York, or
the National Peer
California.
Review Committee.
You know, so we have the right to choose somebody else. It's hard for me to see that we would ever get there. I think the TSCPA, obviously, we have a good...
No, and I'm not slighting the society. I mean, my point is, I think our issue is with the fact that we've authorized this group to manage the program.
And I think that's where we're struggling with this peer review oversight, what we ultimately do here, Trey.
Right.
And I think we're still waiting on the final rules on peer review. I mean, maybe those have now been approved, but they've still been in the process of refining or changing some of those. And once the final rules are approved, I think, again, NASBA is trying to evaluate what role can they play to help the states. Can they step into that peer review oversight role, or do they simply help put together a list of best practices that boards could use, or do they actually send somebody into, the board would contract with them to do the peer review oversight? They're trying to develop a business plan. I mean, they can't just do that if it doesn't kind of sustain itself. I mean, they're and you got some state boards that do have their own PROC. I mean, and some, I mean, like us, that our rules are required or law, but we don't have it.
Right.
The true oversight would be we're either going to call these individuals in when they have back-to-back failures, or if there's a back-to-back failure and the administering entity decides to allow them to stay on the program, there needs to be a rationale for why that is.
Yeah, well, I agree.
And that's where I feel like we're saying we don't know that we can do that.
What's the
I don't know if
current
that's
what's the current process? Because I don't think
there is no process.
Since I've been on the board, I don't think we've had anyone come before us that's failed back-to-back peer review or anything. I don't even know if it happens.
We have not been statutorily and rule. We've not had access to those documents, and we wouldn't know that. Now, we would know if they were terminated for successive failures. That we have had that or would have received that in the past. Now, beginning with any reviews scheduled June 1st of this year and after, we now have access to the results. So we can see earlier on if folks are not complying with peer review, meaning they're getting a pass with deficiencies or a failed peer review. So, but
we have to look that. My question is, if we've authorized the administering entity to do this, why can we not require that they notify us of back-to-back failures?
So that is part of the.
Instead of us having to go to a website and look at everybody's single peer review and say, oh, well, here's this one, let me go back 3 years, let me go try to find it here.
It's just it's outside of the standards of peer review. They just, it's it's confidential, so they can't just tell us.
Even if we're contracting with them to do it on our behalf, I mean, it seems like we should have full.
So our only mechanism for this is the peer review oversight committee. If the board would prefer us to move forward now and try to get this going instead of waiting for what likely.
I don't want to override anything. I'm just thinking from a fundamental view.
Right.
Why is it that our administering entity doesn't have to? I just don't understand. If there's a back-to-back and we're the licensee, we're the people granting the licenses.
Right. But there are confidentiality aspects to the peer review program as determined by the AICPA peer review board, and they do not allow the administering entity to just give us any information that we want. It just doesn't work that way.
But I'm not talking about just any information. I'm just talking about if there are repetitive failures.
So,
would wonder if, we're kind of at a stalemate here, and I want to take a break before we start the hearing.
Maybe Brad or somebody or Kara.
Could we ask you just one more time, Wendy, to double check, communicate with AICPA or TSCPA and see if, make sure this is confidential, that they can't disclose that to us. But what I hear you saying, if we could simply get them, if there is a multiple failures, that's something you notify the state board about. And you're saying it's confidential, but just make sure of that. If we're kind of at a stalemate, there may not be anything we can do until we get this whole peer review oversight.
Well, that goes back to, we need to be making sure that if we get audited for sunset again, they understand that our abilities to oversee peer review is hampered.
Well, and I would also ask, I haven't read the statute in a couple of months since the last meeting, but we have pretty stringent confidentiality requirements on us as a board if we have information about peer review, as I remember, right? So even though we've contracted this out, the statute's set up for us to be able to do it too. So to the extent that that's the case, I would imagine that our statutory obligations are stronger than whatever contractual or policy application the SCPA has. As a result of that, if I was our lawyer, which I'm not, I would say that you have no basis for not disclosing that to us because we're held to the same or higher standard under state law. And there may be a concern at the ASCPA level that we don't want to put a chilling effect on people participating in peer review, and we certainly don't want to open up any type of retaliation or liability to members who are actually doing it. But if we have the ability to keep it out of the public record and out of the live stream, et cetera, which I believe we do, then there shouldn't be a reasonable basis for them to deny us being able to get that information, especially when it's weighed against the balance of protecting the public in Tennessee. So you may want to get, when you have that conversation, have one of our lawyers look through that and see if that argument holds water. We would need to, I think, at the least look at whatever the policy statement is AICPA has. Because, again, it's an organization, it's a policy statement. This is a law, right, that we have. So I think we need to look at the two of those things and compare it and go with our guns blazing best argument to be able to get this information. Even if you're asking for, especially when you're asking for limited information for repeat failures.
Thank you. Satisfactory?
Absolutely.
Yeah. Any other questions or comments? If not, that concludes the executive committee report, and why don't we take a break? And Wendy is our report. Everybody's supposed to be here at 10 o'clock.
Ashley's the attorney, and she's here ready to go, so we'll be waiting on a judge.
Mr. Chairman, before we break, can I just say I need to recuse myself from this hearing because of the nature of it, and so I won't be here, but I'm not skipping out on the board. All right, thank you.
Thank you. Okay, let's take a break and reconvene at 5 minutes after 10, something like that. All right, man.
Before you retire.
Last time I tried to get up on the slalom.
Judge.
Are we waiting for anybody else? No.
Are we ready to start back with the formal hearing? Okay, and I'm not sure who I need to turn this over to at this point. Our judge? Okay.
There it is. Okay. Okay. Good morning, everybody. Today is October 23rd, 2018. This is a hearing before the Commissioner of Commerce and Insurance State Board of Accountancy to take up the matter of Vernola Buchanan. It's docket number 12.19-152035J and case number ACC 201-701-2551. I'm Rob Wilson. I've been assigned by the Secretary of State to preside over the hearing of this matter as administrative law judge. However, in matters such as this, the board sits as their own jury in these matters, so I'm just the gatekeeper of evidence, and I will run the proceeding. Our chairperson is Mr. Stewart, correct? Do you, can we just get everyone to introduce themselves for the record, and then I'll confirm that that constitutes a quorum of your board, and we'll be ready to start.
Okay. Janet, would you please start?
Janet Booker Davis, board member.
Pam Church, board member.
Jack A. Andy Bonner Jr., board member.
Trey Watkins, board member.
Stephen Eldridge, board member.
Casey Stewart, board member.
Judy Weatherby, board member.
Gay Moon, board member.
Larry Elmore, board member.
Evan Monroe, board member.
Okay, thank you. And this does constitute a quorum, correct?
Does constitute a quorum, yes.
Okay. We have attorneys Ashley, Gino, and you're proceeding on your own behalf, correct? Okay. And Sarah Page, representing the state. So let me list the technical record. There is the original notice of hearing and charges, April 24th. This matter was continued once at Ms. Buchanan's request. There's a notice of continuance in the file. There are several witness and exhibit lists filed from the department, a notice of appearance from Ms. Page, notice of appearance from Ms. Gino, and intent to introduce affidavit, and then affidavits also in the files. Is there anything that I didn't mention that I should have?
I think you got it.
Okay. All right. Then, do we have witnesses present here now, or are we going to go get them as we go on? Should we swear everybody in now, or do you want to do it individually?
We can go ahead and do it now.
Okay. Then let's have anybody that's going to be a witness in this matter raise your right hand and answer in the affirmative. Do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth?
I do.
Okay, witnesses are sworn in. If someone else comes that we didn't swear in yet, just remind me, and we'll swear them in at the time. Okay, before we get started, do you want to distribute anything to board members?
Yes, I've got a copy of the notice of hearing and charges.
Okay, then let's go ahead and distribute those to the board members. You can take a quick look at them, and then we'll ask for the record if anyone has any prior knowledge that would prevent you from making a fair and open decision in this matter. And please, members of the board are reminded that during the time the hearing is being conducted, please don't have discussions privately or with each other. We'll make sure that all of discussions are open under the Sunshine Law. Please don't draw any conclusions until you've heard all of the proof. If you get a chance to look over that, just let me know. I would remind the members of the board that the law requires you to disclose on the record any outside knowledge of this case or any communications that you've had, written, verbal, or otherwise, from the parties concerning this matter. During the course of the hearing, there will be an opportunity for each of you to question any of the witnesses under oath. Please reserve any expression of opinions you may have for the discussion part of your hearing. Party desire the rule of sequestering witnesses?
Well, we don't, Your Honor.
Okay. And Ms. Buchanan, you're just the only witness you're going to have for yourself, correct? Okay, so then there's no rule. The rule is to keep everyone's testimony fresh, so if there were more than just one person in the room at a time, but neither side is requesting that, so we'll just go forward. Is there anything else to distribute to board members? Do we need rules or anything?
Not at this time.
Anybody need to disclose on the record any prior knowledge of this matter? Okay. If for some reason when we get going you do realize that you had to, just let me know at the time. Okay. That brings us, unless there's no preliminary motions or stipulations, that brings us to our hearing. So we'll hear opening statements from each side, which are not considered sworn testimony, and then each witness will be questioned, questions from the board members, possibly questions from me, closing statements, board deliberation, that's the whole thing. Let me know if you have any questions, okay? Okay. All right, Ms. Gino, do you want to start with an opening?
Yes, Your Honor.
Okay.
Good morning, Your Honor and board members. Today's case is straightforward. The respondent, Ms. Vernola Buchanan, engaged in unlicensed activity. Specifically, you will hear today the respondent used a test language in a certificate of need application, despite not being licensed by this board. You will hear that the respondent prepared a document which she titled Audited Report, and included phrases such as, quote, "We have audited the accompanying financial statement," close quote, and, quote, "Our audit was also conducted," close quote. As this board is aware, such language is restricted by the laws, rules, and regulations of this board, and someone who is not licensed cannot say that she audited, reviewed, or compiled a financial statement. As such, we would ask the board today to find the respondent in violation of this board's laws, rules, and regulations, and to impose a civil penalty of $1,000 per violation per day. Thank you.
Okay, Ms. Buchanan, did you want to go ahead with an opening statement? Okay, then what you can do is wait for the state to put on their proof, and then you may question their witnesses as well. Sometimes that works. Yeah, I think if you pull that toward you,
push it again. Not at this time.
Okay.
Can you hear me okay?
Mm-hmm. Okay, then Ms. Gino, do you want to call your first witness?
Your Honor, this morning my first witness will be Wendy Garvin.
Okay. And she's already sworn in, so whenever you're ready.
Could you please state your name for the record?
Wendy Garvin.
Who is your employer?
State of Tennessee Board of Accountancy.
What's your business address?
500 James Robertson Parkway, Nashville, Tennessee.
What's your job title?
Executive Director.
How long have you held that position?
3 years.
Can you briefly describe your job responsibilities in that position?
I am responsible for the day-to-day operations of the board, including licensing, complaints, compliance with CPE, financial management.
Are you the custodian of records for the Board of Accountancy?
Yes.
Are you responsible for maintaining their records?
Yes.
Does that include licensing and complaint files?
Yes.
Are you familiar with the laws, rules, and regulations of the Board of Accountancy?
Yes.
Does the Board of Accountancy license CPAs and CPA firms?
Yes.
Is there a procedure for individuals to obtain a license?
Yes.
Are you familiar with the respondent, Vernola Buchanan?
Yes, through this complaint.
Have you reviewed the licensing files to determine whether Ms. Buchanan is licensed by the Board of Accountancy?
Yes, we found no license.
Do you know if she's ever been licensed with the Board of Accountancy?
We were unable to locate a certified public accountant license for her.
Was there a complaint that was submitted against the respondent?
Yes.
Have you reviewed that complaint?
Yes.
Are you familiar with the complaint?
Yes.
Your Honor, at this time I'd like to approach the witness.
Okay.
Do you recognize this document that I've just handed you?
Yes.
What is this document?
This is the complaint filed against Ms. Buchanan.
Is this a true and accurate copy of the complaint that was filed?
Yes.
When was this complaint filed?
February 24th of 2017.
Who filed the complaint?
I filed the complaint based on a referral from the Tennessee Health Services and Development Agency.
Does the department maintain this type of document in its normal course of business?
Yes.
Your Honor, at this time I would like to move the complaint to be exhibit number 1.
Mark the complaint as exhibit number 1.
Ms. Garvin, what are the allegations contained within the complaint?
Allegations are that Ms. Buchanan completed an audit report in conjunction with a certificate of need application.
Did the respondent respond to this complaint?
Not that I'm aware of.
Your Honor, may I approach the witness?
Yes.
Ms. Garvin, do you recognize the document I've just handed you?
Yes, I believe this is the complaint file. An affidavit related to the complaint.
Thank you. Whose affidavit is this?
This is an affidavit from Melanie Hill. I believe she is with the department that referred the complaint.
Your Honor, this affidavit was the affidavit that was submitted along with its exhibits as part of the notice of intent to which the respondent did not reply to.
Okay.
So at this time, I would like to go ahead and enter this as exhibit number 2.
Okay. Is this more than one affidavit, or is the whole thing like collective exhibit?
It's a collective exhibit. It's one affidavit with exhibits attached to the affidavit.
Okay, then we'll mark the affidavit of Melanie Hill along with the attached exhibits as exhibit number 2.
Thank you. Ms. Garvin, can you please read the affidavit into the record?
Sure. Comes now the affiant Melanie Hill under penalty of perjury, who, being duly sworn, deposes and says to wit as follows: I am over 18 years old. I currently serve as the Executive Director for the Tennessee Health Services and Development Agency. In that capacity, I'm responsible for the daily operations of the Tennessee Health Services and Development Agency. As part of its mandated duties, HSDA is responsible for regulating the healthcare industry in Tennessee through the Certificate of Need program. A certificate of need is a permit for the establishment or modification of a healthcare institution, facility, or service at a designated location. The Certificate of Need program assures that healthcare projects are accomplished in an orderly, economical manner consistent with the development of adequate and effective healthcare for the people of Tennessee. In order for a person to obtain a certificate of need, an application is submitted to HSDA. HSDA has a duty to process certificate of need applications and has done so as part of its normal duties and functions. All certificate of need applications are housed and processed by HSDA upon submission. As part of my duties as the Executive Director, I am the keeper and custodian of records for the HSDA and responsible for maintaining those records, which includes all certificate of need application files. On or about August 8, 2016, a certificate of need application was submitted to HSDA by Premier Healthcare PLLC. On or about August 19, 2016, HSDA's HSD examiner, who reviewed the application for completeness, sent supplemental questions to the applicant. A copy of the supplemental questions dated August 19, 2016 is attached herein as Exhibit A. Question 20 requested the applicant provide audited financial statements. On or about September 28, 2016, the applicant submitted responses to the supplemental questions of August 19, 2016. These responses were submitted under oath. A copy of the responses, dated September 28, 2016, is attached hereto as Exhibit B. In response to HSDA staff's request for audited financial statements, the applicant stated, "Please see attached audited financial statement." However, there was no attachment. On or about October 11, 2016, the applicant submitted responses to additional supplemental questions. A copy of the responses dated October 11, 2016 is attached herein as Exhibit C. In response to HSDA staff's request for audited financial statements, Question 13, the applicant stated, "Please see attached audited financial statement." An attachment was included purporting to be prepared by Vernola Buchanan on behalf of, or DBA, verb, the ultimate action word. This document, dated September 19, 2016, stated, among other things, that we have audited the accompanying financial statement and our audit was conducted in accordance with generally accepted auditing principles. On or about October 13, 2016, HSDA's HSD examiner, who reviewed the application for completeness, sent supplemental questions to the applicant. Copy of the supplemental questions dated October 13, 2016 is attached herein as Exhibit D. Question number 3 indicated that a review of the Tennessee Secretary of State website indicates verb, the ultimate action word, corporation, is inactive, dissolved, as of August 9, 2011. Information was requested regarding Vernola Buchanan's credentials to conduct a financial audit. HSDA files do not contain any response to that request for information. Under my direction, HSDA staff prepares an application for HSDA members' review before HSDA meets to approve or deny applications. Typically, this consists primarily of the original application with irrelevant information removed and relevant information developed during the review process. A copy of the application sent to members in the Premier Healthcare PLLC matter with the HSDA staff summary for HSDA members is attached as Exhibit E. On February 22, 2017, HSDA considered the application at its regularly scheduled public meeting. No representative from the applicant appeared. HSDA unanimously denied the application. A copy of the relevant portion of HSDA minutes is attached as Exhibit F. The attached Certificate of Need application, Exhibit E above, was forwarded to the Tennessee Board of Accountancy in order to review for any issues regarding Buchanan's documentation prepared as part of the application. Further affiant saith not. Melanie Hill.
Thank you. Ms. Garvin, I'd like to direct your attention to the first blue tab labeled 1. Can you please read item 13?
Section C, Economic Feasibility, Item 10. The referenced audited financial statements could not be found. Please provide as an attachment to the supplemental response. Please see attached audited financial statement.
I would now like to direct your attention to the second blue tab labeled with a 2. Can you please state what this document is?
This document is titled Audited Report.
Is this document signed?
Yes.
Who signed the document?
It is signed by Vernola Buchanan, verb, the ultimate action word.
Ms. Garvin, can you please read this report into the record?
To the Director of Premier Healthcare, we have audited the accompanying financial statement of Premier Healthcare, which is comprised of a financial statement year ending December 31st, 2015. Our audit was also conducted in accordance with generally accepted auditing principles. These standards require that the audit be planned and conducted so as to provide reasonable degree of certainty that there are no major inaccuracies in this report on costs. The audit includes review of documents contained in this report. As is the case in many organizations of this kind, Premier Healthcare's income was a review of the deposits reported in the books. In our opinion, this audited report faithfully reflects every major respect the accumulated costs Premier Healthcare financials during the period of 2015 in accordance with generally accepted accounting principles.
If I could now direct your attention to the third blue tab, which is labeled with a 3. What is this document?
This is titled Financial Statement.
Ms. Garvin, can you please confirm one more time whether the respondent is licensed by the Board of Accountancy?
Based on our records, the respondent is not licensed with this board.
Thank you. I have no further questions for this witness.
Okay. Ms. Buchanan, do you have any questions to ask of the witness? Okay. Questions from board members for this witness? Anyone?
Do you have any questions? Oh.
Okay. Okay, do you want to call your next witness?
Your Honor, at this time I would like to call my next witness, Sharon Waugh.
Okay, and this witness was here when we swore in too, so whenever you're ready.
Can you please state your name for the record?
Sharon Waugh,
Who is your employer?
State of Tennessee Board of Accountancy,
What's your business address?
500 James Robertson Parkway here in Nashville.
What's your job title?
I'm the investigator for the board.
How long have you held that position?
About 17 months.
Can you briefly summarize your job responsibilities in that position?
I'm responsible for reviewing any complaints that are referred to me from the legal counsel, and I do assist the executive director on special projects.
Are you a licensed CPA in the state of Tennessee?
Yes, I am.
How long have you been a licensed CPA?
In Tennessee since 2007, and prior to that I was licensed in California.
How long were you licensed in California?
Since 1992.
What's your educational background?
I have a bachelor's degree in accounting, actually business administration with a concentration in accounting, and I have a master's in accountancy.
Are you a member of any professional accounting associations?
Yes, I am a member of the TSCPA.
What experience do you have in the field of accounting?
I have 30-plus years in a variety of areas within accounting, including auditing, taxation, as well as I have worked as a controller in a manufacturing environment in the past as well, and I do have some experience in education as well.
Do you have any industry specializations?
I've worked within government, not-for-profits. I do have some limited experience in terms of nursing homes and that type of activity, manufacturing. It's just a wide variety.
Are you familiar with the laws, rules, and regulations of the Board of Accountancy?
Yes, I am.
Based on your education and experience, do you feel you can give an opinion in this matter concerning the report submitted by the respondent?
Yes, I can.
Your Honor, at this time I'd like to ask to approach the witness.
Okay.
Do you recognize the document I've just handed you?
Yes.
What is this document?
This is a copy of my resume.
Your Honor, at this time I'd like to move to enter the resume as Exhibit 3.
Okay, we'll mark the resume of Sharon Waugh as Exhibit 3.
Thank you. Ms. Wall, do you believe that your testimony will be helpful in assisting the judge and board understand the evidence in this case?
Yes.
Do you believe you can reasonably apply reliable principles and methods to the facts of this case?
Yes.
Your Honor, at this time, I would like to move to tender Ms. Wall as an expert witness based on her education and experience and the testimony she's provided thus far.
Okay, based on her resume and experience, we'll mark for the record that Ms. Waugh is an expert witness.
Thank you. Ms. Waugh, are you familiar with the complaint against the respondent?
Yes.
Have you reviewed that complaint?
Yes.
Have you reviewed Ms. Hill's affidavit?
Yes.
And the certificate of need that was attached
Yes.
to that affidavit? In that review, did you also review the respondent's report?
Yes.
Did you review any other documents?
I don't believe so. I think that's complete.
Ms. Waugh, in your review, did you find any issues with the respondent's report?
Yes, I did.
What issues did you find?
Basically, the respondent is not a licensee. The report that I reviewed clearly had language that's contained in an audit report that's restricted to those people who are licensees of the state.
What specific language did she use?
I believe in the first paragraph, I don't have it in front of me, but she does say that she had audited the financial statement and that she had completed an audit in accordance with generally accepted accounting principles, I think in the second paragraph of the report.
Your Honor, may we approach the witness with a copy of Exhibit Number 2?
Yes.
Ms. Waugh, can you again say what specific language you were just referencing now that you have the report in front of you?
I'm referencing tab 2 of what was forwarded to me. In the first paragraph of the audited report, actually the title audited report would be considered restricted language as well under Tennessee Code Annotated. But in the first paragraph, it says, we have audited the accompanying financial statement of Premier Healthcare. Again, this would be restricted language included in an audit report that is restricted for the use of licensees only. And when I look into the second paragraph, I see our audit was also in accordance with generally accepted auditing principles. Again, this is restricted language according to Tennessee Code Annotated 62-1-113H1, as it is in a test engagement. And I should say, I see in the third paragraph that there is another reference in terms of, in our opinion, as a non-licensee, she cannot issue an opinion on a client, and then the language, this audited report.
Thank you. Now, you said this was restricted language. Is this language restricted because it's attest services?
Exactly. In the state of Tennessee, only those individuals who are licensees of the state of Tennessee can complete attest work or issue language that is included in reports that represent a test work, which is defined as audits, reviews, compilations, as well as any other attestation agreements.
And all of that is defined in the Board of Accountancy statutes and regulations and rules, correct?
That is correct.
Does providing a task services require a license?
Yes.
Ms. Watt, is there any safe language that a non-licensed, safe harbor language that a non-licensed person could use?
Yes.
Does it look like the respondent used any safe harbor language in her report?
No, she did not.
Ms. Watt, do you believe the respondent's report used terminology that could lead someone to believe it was an actual audit?
Yes.
Thank you, Ms. Watt. I have no further questions.
Okay, thank you. Ms. Buchanan, do you have any questions to ask of Ms. Waugh?
Only question that I have is,
Actually, I did not. I did not.
Could we ask the respondent to speak up a little bit or more into the microphone, because I cannot hear what she said.
And if you press the speak button and the red light goes on, I think that'll be better. I think the question was, did Ms. Waugh work as an intern? Correct?
I actually did not have an internship. They weren't as common in those days as they are currently.
Other questions for Ms. Waugh? Anything on redirect?
No, Your Honor.
Questions from board members for Ms. Waugh?
Does anyone have any questions? I do not, and do not see anyone else that has questions.
Okay. Thank you.
Hang on, sorry.
Go ahead.
The report was signed by the respondent. Is that correct? This report that was submitted was signed?
Yes, it is signed by Vernola Buchanan.
Okay. Just making sure.
Okay. Okay. Do you want to call another witness?
That is all of our witnesses, Your Honor.
Buchanan, now would be your opportunity to get any testimony on the record that you want to get, and you can just speak in the narrative, and then the state's attorney may have questions for you and questions from the board as well. Okay? The speak button again.
speak to Ms. Garvin or?
This would just be your opportunity to get anything you want to add to the record. You know how like she asked her witness questions, or you wouldn't ask yourself questions because you're proceeding on your own behalf, but you can just testify in the narrative. Anything pertaining to what the state is alleging that you would like the board to know.
Originally, when Ms. Smith asked me to assist her with this.
I think
pull the microphone forward maybe, because it'll work automatically if you pull it. Will it not? That one spot maybe?
It might be helpful if she moves up to the witness stand.
Ms. Buchanan, I think that would be a good idea if you move to the witness chair, unless that one reached.
Is this better?
I can hear it now, but if that red light goes out, then it gets quiet again, and it just went out. Okay.
Originally, when Ms. Smith informed me about this She originally informed me about this situation as far as needing the statements, as far as the financial statements. It wasn't like she needed a CPA. She told me she just needed the financial statements, and since I wasn't an employee of hers, I've been knowing her for years. And I wasn't working, and the way that the verb came into play was that I originally was getting ready to start that business before I got sick. And I didn't start the business. I actually had the phone service on, and because the phone was still on and it was listed in the phone with AT&T, that was the way that I could be contacted. So I didn't have a personal phone, and we went back and forth, and since it was the state and I didn't have a direct phone line, that's how the verb came into play. And I never answered the phone, and someone could always leave me a message. And I didn't have a cell phone that was active at the time. And we went back and forth on whether or not to even list the verb, because I didn't think it would be right to list the verb since it wasn't an active business. And she told me that, and I know that's a lot of hearsay, but she informed me that it would be okay if, since I wasn't a CPA, it would be okay, since I had the years of experience, to go ahead and do her financial statements. And she was the one who was like, she needed the letter to include in with her package. And once Ms. Garvin read the information, that's when I just found out about, because I never read this. I've been going back and forth to the doctor. I received migraine shots, and I just been having a lot of medical issues. And I go to the doctor more than the average person does. And that's how a lot of the gaps in time happen, because I just never could communicate with anybody. And that's how she got in contact with me, because she just needed somebody to help her to complete her package. So even down to her resume that she submitted in, her package, to just a lot of things that she needed in her package, I actually assisted her with, because that was a type of work that I did in the past. And I actually brought some of the things, because I've been knowing her for years. We went to church together, and I went back and I found like a lot of old emails dated back like for years, where back to 2008, 2009, communicated back and forth about different situations that I've assisted her with. And it just showed the different types of work that I've done in the past, different types of situations. And that's including the things that I've done with her. And as far as like financial statements, I've always done different types of statements with different companies. That's why I asked about like internships, because I've done internships with different CPA firms. And that was from 2005 up until I've personally have a background in quality planning and cost analysis, accounting, banking and finance, So I do have a business background, but of course I don't have a CPA. And I never said in any other information, regardless to the type of wording that I used in the letter, I never stated, nor did I put behind my name CPA. And I just never ran into a situation where I had anything like this. Outstanding remarks behind the work that I've done. So this was like one of the situations that I was just blown away with. So yes, now I know the things that I cannot do in Tennessee, but I haven't been able to do any type of work. This was like one of the things that I've done for somebody that I went to church with and called myself doing something for somebody that I actually cared about, but this ended up biting me at the end. And now I couldn't even get her to even give me a letter saying that I didn't charge her anything. She didn't pay me anything. And I even got a text message where I sent her a text asking her to give me a letter saying that I didn't charge her, she didn't pay me, and texts and calls and everything where I've been trying to get information back from her, and she wouldn't even give me the letter. So this in turn saying that her application was denied because of the situation, that meant that she, of course, was being very deceitful in the whole situation. So that's basically what I have to say.
Okay. Ms. Gino or Ms. Page, questions for Ms. Buchanan?
Good morning, Ms. Buchanan. I just have a couple questions for you. Ms. Buchanan, you're not licensed by this board, are you? And Ms. Buchanan, you prepared the report that is contained within Exhibit 2, specifically the number 2 and number 3 blue tabs. Thank you. That's all the questions I have.
Okay. Ms. Buchanan, anything further you want to add before we see if board members have questions for you? Okay. Any questions from board members for Ms. Buchanan?
I have a couple of questions, okay, and I'm sure other board members will too, but you've admitted that you prepared this report. You made a statement a few minutes ago that you now understand what you cannot do. My question would be, have you ever done reports like this before? Is this the only one that you've done?
This is the only one that I've ever done like this that has been turned in to the state.
Have you done other reports that would be titled audit report? You've never done that before. Have you ever used language similar to the language that's in these 3 paragraphs in this report? And you totally understand that you cannot do this going forward. This application was denied, as I understand it. The whole package, the application in which this report was included, was denied. Is that your understanding? Do you believe there's anyone out there in the public that has been harmed by this report, the issuance of this report? Microphone, please.
I don't believe anybody has been harmed. I've been deceived by Ms. Smith during this whole incident And my plan is to write her a formal letter about this whole incident, because this was just, I just can't believe she did this. I mean, I was just, I'm hurt by the whole situation because we all went to church together. That's just how deep this whole thing is, because we went to church for years together. And I just can't believe that she did this. And it just went so far. And for her to turn around, and then all I did was just ask her to do one simple thing, and then for her not to even do, because I took my son up there with me, and we don't have anybody. You see, he's with me now, and we don't have anybody. And this is it. This is my family. Everybody else in my family has passed. So this is it. So it's nobody else that I can turn to. And for me to have to do this and to take him from school and bring him with me, we woke up at 3 o'clock this morning and got on the expressway. And for her to turn around and cause this whole situation, I just can't believe it. And I just can't, I can't believe it. And we were up there. I spent so much time up there with her, and she thought that I was just going to make up some numbers for her. And I told her that this is not something that you can make up. I sat there and physically spent a week and a half with her. 1 week going through her actual physical paperwork. And then I stayed up there half of the night. I called a friend of mine that stays in Stanton, Tennessee, to take him to a pumpkin patch. And then I stayed another day. So it wasn't just like I just didn't put my whole heart into it. I spent all of that time with her because I had vested time into it, because I wanted her to succeed. I wanted her to do well. And that's how I feel about everything. And anybody that I do anything for, I want them to be successful in what they do. So it's not like I just threw it out there and just said, you just do whatever, I don't care. I wanted her to make it and then be able to say, okay, Vernola helped me. So I wanted her to be successful.
You're not aware of anyone else in the public that's relying on a report like this that you've been involved with? Okay. I guess I'd just like to clarify, you're saying the time that you just outlined for us you spent on this, you were not compensated in any way for that time? Okay, does other board members have some questions?
What services does the verb, what is the verb? I mean, I know it's your business, but what services do you provide? Does it provide, or did it provide, or did you advertise it to provide?
I didn't advertise that to do anything. The business that this was supposed to take the place for was SNAP Secretarial Services. And it did anything from helping you to start your business to marketing, taxes, just a little bit of everything. And marketing material. It's just a whole lot of everything. And it's a group of women together. And it's to help you to stay motivated in your business. And if you needed computer training, it's somebody to help you with your computer training. Education, we have somebody that can help you with your, say your term papers. There's a professor that can help you with that. If you need help with just all sorts of, just everything.
Bookkeeping services for clients.
bookkeeping, everything.
I know you said that you've never performed any other audits besides the one that we're talking about.
Not audits.
What about reviews or compilations?
Just receipts, just that part.
Never given an opinion on any other financial statement?
Even the receipts.
Shannon,
I'm sorry.
Oh, go ahead. Go ahead, Trey.
Where did you get the language for the report that you put in this packet?
Textbooks.
You pulled it out of textbooks?
Mm-hmm.
Okay. You had referred to the fact that you did internships in which you prepared a large variety of reports. Did you sign those reports? Or did your manager or supervisor or your owner of the business sign it?
Just the manager did.
Okay. One of the things I hear you saying is that you were deceived, and I firmly believe you were deceived. But do you understand that when you sign anything, that's you on the hook? That regardless of what anybody tells you or not, if you're signing something, that's you, right? Last question I have for you is, how bad would a financial penalty harm you and your family? How badly would a financial penalty harm you and your family at this point? Okay, that's my only questions.
I wanted to ask Ms. Buchanan if you were aware of the restrictions of the use of the language that you used in that report that you signed. Just to ask you real quickly, what is your educational background? Do you have a degree in accounting, or do you, I'm not sure if you received any formal training?
Associate degrees.
Okay. What are those, for the record?
Is transportation and logistics, banking and finance, and the other one is just a general management degree.
Okay. So it's safe to say that that's just not something that you knew anything of. And the textbook, I wondered if you, Trey, asked a good question on that.
Well, that's just,
I didn't know if it was online.
You have to take accounting anyway.
So
it's
you
just,
didn't obtain that language online. You obtained it from a textbook.
Right.
And I guess in the context of that textbook,
Principles of accounting,
it shows that that's
what you do.
Issued by an accounting firm.
It's just principles
firm.
of accounting.
Okay. Was this the first time you helped Ms. Smith or Premier Healthcare with any applications or anything like that?
That was the first time.
Okay. And who owns Premier?
Full name is Katandria Smith.
Okay. And do you have any ownership in that company? Okay. And double check here. Okay. Okay, I think that concludes my question.
Can I ask one more question? Are you currently working now? Not at all.
Can I ask, what is it that you're hoping to get out of this process?
Well, I just wanted to come and just really just say that I didn't have the knowledge that this actually was I didn't have the knowledge that this happened the way it did. That the code, that because I didn't say I was a CPA, what was told to me that I didn't have to be a CPA to complete the document. I was told that as long as I had the experience that I could, and I didn't want to not come. I wanted to make sure I came, because I don't feel good. I just want it to come.
What's the background of this person who was asking you, directing you to?
The owner of Premier.
I mean, is she a CPA or business degree person, or do you have an idea of her?
As far as I know, she has a business degree.
She's not a CPA.
No, she's not a CPA.
Thank you.
Other questions from board members?
I just have one more question. I'd like to ask the investigator a question, if I may.
Which?
Sharon.
Okay.
Sharon. Hey, Sharon, thanks for coming back up. I just wanted to ask, throughout this process, has Ms. Buchanan been cooperative and forthcoming with the situation that
I have had no interaction with Ms. Buchanan, and RFI was not assigned for this. My role was limited to looking at the report and making assessments of whether that was an audit report or not. That's been the extent of my involvement.
May I also ask the question of Wendy Garvin?
Wait, you can just answer from there.
Same question. Your interactions with Ms. Buchanan, was she cooperative?
We have not had any. I have not had any interaction with Ms. Buchanan. To my knowledge, the complaint was filed. We requested a response. We never received a response. We did have indication that she had received the complaint. However, until today, we had been unable to obtain her side of the story.
Okay. And one last question for you, Ms. Buchanan. Did you realize, as best I can tell from what I've looked at, this involved government funding. This application was submitted to a government agency which would provide government funding, which in this instance, I don't know how carefully, as you admitted, you don't have the qualifications and the license to prepare such a report, but I guess what concerns me here is that whether, this other lady, pressured you to prepare something or whatever, is that this is submitted, and had it not been caught, there could have been, government funding involved and whatnot. It's very serious, in my opinion. This is, and I do have a lot of compassion that you didn't understand about the financial statements, because I also am not a CPA, and I did not know that prior to being part of this board, that I couldn't call myself an accountant or whatnot. So I do have a great deal of compassion. I just think I would use caution on filling out any paperwork with regard to government funding or anything like that, and just be very careful, as Trey said, before you sign your name to something. That's it for me.
Any other questions from board members? Okay, then proof?
No further proof.
Closing.
I would like to submit a closing.
Okay.
Board members, I know that we heard Ms. Buchanan's side of the story for the first time today, but I would like to remind you that she did admit that she is not licensed with this board, and that she did admit to preparing that report, which she signed. And in that report, despite not being licensed by this board, She used language that she should not have used. And that report was attached to a certificate of need application that was submitted to a government agency. Again, Ms. Buchanan signed that report and knows she is not licensed. So as such, I would again ask this board, as I did in the opening, to assess a civil penalty against Ms. Buchanan of $1,000 per violation per day. I would also ask this board to assess costs against Ms. Buchanan as well. Thank you.
Ms. Buchanan, do you want to make a closing statement? Okay. Okay. Let's see. Are you ready for a board charge then?
And can I ask how much
Yes.
the cost, the total amount of this fee would be? You said $1,000 per violation per
I don't know
day.
if we know the court cost at this point.
Well, yeah, maybe we don't know the court cost, but how much are we talking about? Total.
This is Ashley's first hearing, so I can speak a little bit to costs.
Okay.
It costs us about $200 for us to file the case with the administrative law judge. We also will receive a bill from the administrative law judge's office of a breakdown of the time spent on the case, and we will pay an hourly rate of what exceeds that $200 initial cost.
We need to deliberate quickly.
Exactly. Then our court reporter, this will likely, I think it'll be either a half day or full day charge, which can vary from $150 to $350 depending on the contract. So for this case, considering we didn't fully engage Sherry and all these elements, I would guess the costs were around $500 to $600. That would be, but that is an approximation as always because we have not received our bills.
Okay, I guess my main question was the $1,000 per violation per day. What does, is that $5,000? I mean, what is that amount?
That is the civil penalty. That is your authority as a board to determine discipline. That is the max penalty you are allowed. So it's your
Okay,
discretion.
how many violations do we have and how many days are we talking about? I'm just trying to figure, is it $1,000 times 2 violations times 5 days, or?
I don't have a recommendation.
After the board charge, you'll receive the proposed findings of facts and conclusions of law with us, which will lay out what we believe happened and also what statutes there are. And then we would turn it over to you all to determine.
You don't, okay.
Okay.
I've got some things I want to say in the matter, but I don't know if it should be now or after you give us our charge, because it's part of the deliberation.
Okay, yeah, then let me just do a short charge. There's not, you've all done this before, so the charge is not long at all, and then you can have your open deliberations on the record. So let's do that, unless anybody needs a short break. Okay, let's just go right into that then. So we had a closing statement here. Ms. Buchanan basically waived closing, which would then bring it to the board charge. The board has now heard the proof in the case of Bernola Buchanan. The state in this case has alleged in its notice of charges that the respondent has violated the law and regulations of the state, which they will hand out in a proposed order, I understand, so which you can go through then and accept or not accept. As sole and exclusive finder of facts in this matter, you must conduct open deliberations and make findings of fact and reach conclusions of law based on the facts found, determine the penalty if appropriate, and give policy reason for your decision. Please make your findings based only on information that you heard here today, and any documentary legal evidence that was introduced. A notice of charges filed by the state and any answer filed by the respondent are not considered evidence, but you may use either or both of these documents to assist you in making your findings. Law presumes that witnesses who are sworn to the oath testify to the truth. It is the obligation of the finder of fact to attempt to reconcile any discrepancies in the testimony between witnesses, but if this is impossible, it is necessary for the triers of fact to determine which witness speaks from the truth and which witness has stated a falsehood despite their oath. In determining which witnesses were believable, the board, as fact finder, has wide discretion. Didn't have any objections, so I don't believe we need to go into that part. Okay, nothing was excluded. So we did certify a witness, for an expert witness for the record, a witness who has special knowledge, skill, experience, training, or education in a particular science, profession, or occupation, may give his or her opinion, this was Ms. Waugh, as an expert to any matter in which he or she is skilled. In determining the weight to be given such opinion and in resolving conflicts in the testimony of different expert witnesses, but we only had one, you should consider the relative qualifications and credibility of the expert, as well as the reasons, the facts, and any other matters upon which their opinion may have been based. You are not bound to adopt any expert's opinion. Give the weight to any testimony that you feel that it deserves. Although you can only consider the competent evidence presented during this hearing in making your decision, this does not mean you are required to set aside your common knowledge or expertise in the field. The state has the burden in this matter, correct? So the burden of proof is by a preponderance of the evidence, means that the amount of factual information presented to you in this hearing which is sufficient to cause you to believe that the allegation is probably true. Any questions at all? If not, I will turn over the deliberations to Chairperson Stewart.
Yeah, I've just got a few comments here, and
and I'm sorry, did you want to pass out a proposed finding, and that way you'll have that to look at? Go ahead. I'm sorry.
Yes, Your Honor.
Go ahead.
I mean, this seems to be very straightforward. I personally feel like based on the preponderance of evidence, the state has met the burden of proof in this case. Matter of fact, I hear the respondent doesn't really disagree with any of the allegations of fact. I really believe this could have been handled without a hearing, but I also heard that that's because the respondent didn't really get back with us until today. We didn't know where she stood or what her version of things were, but I can't help but believe it would have been better to have handled this before we got to a formal hearing today. It's significant to me that she says she understands she cannot do this going forward. She cannot issue audit reports, cannot use language like this, and that she now understands that she cannot do that. I do believe that she is somewhat of a victim in this case. I don't know what you do with that other than I think she just was kind of led in a direction she shouldn't have gone, and this is a violation of our laws, I think. But also, I would say I don't see anyone that was harmed here. I mean, had she issued an audit report that went to a financial institution or somebody that redistributed that report such that people relied on it, I can't help but consider the fact that this only went one place and it was in an application and the application was denied. So I don't really see any big monetary harm in the public out there. That doesn't make it okay, but to me that is a factor to consider. So I guess I think we still have the responsibility to enforce our laws and rules, I think we've got to assess some kind of penalty or fine here, including reimbursement of these court costs that we've talked about. But my personal feeling is we need to be pretty lenient here. Everything considered, the fact that no one was, that I can see, financially harmed, and all the other comments I've just made, I feel that we need to be very lenient here with the respondent. So, what else?
Mr. Stewart, I'd like to second what you're saying. I think we probably have a obligation to the state to charge back the cost of this hearing, and maybe we could work out an appropriate payment plan over some period of time to pay that back. I'm not in favor of assessing any penalties because I think that would be overkill at this point. I would like to perhaps have respondent sign some sort of document that maybe outlines unlicensed activity as defined in our language, and I'm talking along the lines of using the word accountant and things of that nature, because we have a section of that stuff, I guess, just so she can acknowledge that she understands that these are items that she cannot do. But beyond that, I would agree with Mr. Stewart that, I think maybe it's appropriate to charge the cost of this hearing, but I'm not in favor of going beyond that.
I also agree with that. I believe that all the facts, what all she's saying. I will say, though, that you do have a responsibility to know limits, what you can and can't do. So, I'm sympathetic. There's a victim. You're a victim, but you also have to know what services you were able to provide. I know you didn't contest the guilt. I wish you'd been a little more responsive, I guess, to have potentially have avoided this hearing. We've incurred costs that we otherwise may not need to, but I agree with what Trey and Casey both have said, that, I think that the court costs would need to be reimbursed. I'm not personally in favor of a penalty. I don't think it's going to make any difference there. But also that the commitment that you're not going to do this again and not perform any services related to audit or attestation or anything that a CPA that have to be licensed by this board to do. I do comment how well you've taught this young man to behave during this hearing. I've been very impressed, and I need some tips on that. So I'll get with you afterwards on that.
I wanted to just say, Ms. Buchanan, I think that, I guess I'm not speaking to that. For us to consider, we know that normally, through our normal process, this would have been handled with a simple letter of warning through our legal team. As we go through our legal report and have our committee meetings and whatnot, we would have easily foregone any penalty or whatever. And I think we're here today because Ms. Buchanan didn't respond to things, and I'm sure that it's pretty instills a great deal of fear when you get some legal action paperwork and you've done something you didn't know was wrong or whatever. But I don't know. I would petition the board to consider waiving the court cost and waiving any kind of penalty. I think we're here. I don't think there was any intent to do any harm here at all. And I think we find ourselves here because this situation was overwhelming to someone who did not understand the rules and the laws. And I feel like it would be a huge financial burden, even for the court cost. And the defendant was not paid. She's admitted she was not paid anything for this service. So there's not. It's not like a portion of what she got paid would help with this or whatever. So I think we should seriously consider. She's had expenses coming here today, going back home, And
I think
That would be my thought.
also we always consider extenuating circumstances, and she has made clear that there were issues of health, and it sounds like a financial burden. She mentioned the phone issue, that she didn't have a phone at some point. So I think those are extenuating circumstances.
I'm mindful of the example that Fiorello LaGuardia set when he was mayor of New York. He would sit in night court and adjudicate hearings because he was legally empowered to do so, and there was an element where he felt compelled by justice to find the defendant, who was clearly guilty. He did that. He set that order, but then he had every attorney in that courtroom ante up out of their own pockets to pay that fine. And I really think that's an instructive lesson for us. I would share your view, Judy. I don't know, other than creating more hardship, what an assessment would serve. And I am mindful of the costs that have been incurred by the Board of Accountancy, but I also have to weigh the costs and the burden that would place on the respondent. And so I would not be in favor of either a civil penalty, and I would be in favor of waiving the proceeding costs.
I considered that, and obviously I'm sympathetic to the cause, but I think that where I've landed on this, just to give my understanding where I'm coming from, is I think we've got a violation against the laws of our membership, and I think it would almost be a slap in the face to say we're going to make y'all pay for this, something that was a violation against our laws. And that's kind of where our duty as a board is to protect the public and also look out for our membership, and our licensees, and that's who would be, in essence, be paying for this at the end of the day. I'm not fighting or any other way, but I just think that's just where I've landed on this deal. I don't think a civil penalty would be helpful, but I think that some sort of payment plan, just because there's a reimbursement, because there was a lack of response from Ms. Buchanan. Obviously, I wish it had happened a different way, and we'd had a response, and we could have done it with a letter of warning or whatever we would have done. But that's my opinion there.
My thinking is, I could be okay either way with assessing maybe some part of the court cost or none of the court cost, no penalties. But I like Trey's idea of signing this statement, acknowledging the things that you're not supposed to do, regardless of whether there's any monetary amount paid. I think doing that statement would definitely be a good thing to do.
Okay, any other comments? Go ahead, Andy.
I was just going to say, I thought Kevin brought up a great statement about LaGuardia, and I'm sitting here kind of having trouble with the fact that what message are we sending out to the public as regulators, in that we do have a violation. It could have been extremely serious if the funding had been made. We do have other factors that indicate that Ms. Buchanan had experience in accounting firms as an intern, that she knew that she couldn't sign the reports. There was representations made. We don't know if these financial statements were ever used for any other purpose, as going to a bank or anything else. And so I'm very much in favor of a signed statement that she knows that she definitely cannot do those services, and because we send a bad message out to everybody else that may just decide to hang up another verb up and make statements. With all that said, my heart is really on the table as far as the fines, and also the costs would be a burden to you, as the burden was for you to come up. But we all as individuals have the need to to put ourselves in a position where we reach out before we get to this problem. And I hate that it has come to that. But I'm not in favor of a penalty, but I am in favor of asking the board, with 11 people sitting here, if I don't think this should be a burden of of the state, a burden of our licensees, and we are responsible for actually interpreting and regulating what the laws of the state are. And I would ask that maybe we consider reaching in our own pockets and paying the court cost in honor of LaGuardia and in honor of this lady and just her needs and circumstances. And
I'd be in favor of that.
I would be willing to be one of the ones
Me too.
to once we get that cost, that we split that up, because we're the ones here making the decision, and I don't think that's right to put that burden back on the state.
Can we legally do that? Because I think there's enough sentiment to.
I think there's a bunch of politicians in this room. I've been shaking down this election season.
I don't see anything prohibiting it. Do you?
Your Honor, I'll make the point to you, so I'm not negotiating. So the board, as far as the conversation about having a signed letter, there is not authority at this level of the proceedings. They are bound to either dismiss the action, I believe, or they can assess a penalty with a minimum of $100, maximum of $1,000 per violation per day. They may assess investigatory, prosecutorial, and hearing costs. They could do nothing, but some of the actions I think that are being discussed come from our settlement portions of our hearings, but there is not direct statutory authority. As far as board members individually paying costs, that would be, I think it's actually going to be an administrative question that I cannot answer today. I would
technically have to gift that money, I assume, to her to then pay the penalty. We could start a GoFundMe page.
So I think so.
I would
okay, now
caution as maybe a conflict.
Right, and I'm not telling anybody what to do, because you sound like you're completely on the right track, but as Ms. Page just stated, it looks like you're looking to dismiss the action because
we can't have a statement of acknowledgement of violation of the law.
Well, if this were a consent decree, you could have done that, but at this point, I see what Ms. Page is saying. There's nothing that we can write up. Well,
people do this all the time.
They
say there's enough evidence to convict them.
Right. I mean, in this, I guess you could put something in words to the effect of that. Now Ms. Buchanan understands that such a representation cannot be made. I don't see why that couldn't be in your conclusions.
Finding, perhaps, or conclusion.
Right.
You can include that in the order.
Right.
Sure. Absolutely. We'd be happy to add anything, obviously, that the board wishes.
I think that's where we are, and it did. So it does sound like you do want to dismiss the actual charge.
No, I don't think
charges.
Nobody is dismissing a charge. I think we're totally acknowledging the fact that there were violations of law. We just do not feel compelled to assess a civil penalty at this point, and there is some debate on court fees.
Did you say a minimum of $100? So we have to assess?
If you assess a penalty,
if we don't dismiss it, it's like it never happened. If we don't dismiss it, we have to charge $100.
I'm so sorry. I was working on motor V. You do. So I'm not. It's weird to talk to you all, and it's procedurally odd to do this. But
I could ask another question just to really confuse.
Well, just you can find a violation and choose to assess no discipline. That is within your power as well. It's just,
I thought I heard a minimum of $100.
I think that was motor V. Sorry about that. It was my other thing, but you do have a cap of 1,000, obviously. But you do not have to assess discipline and can still find a violation that is within your power. You have total control over the discipline, so long as you have the authority to assess it. If that makes sense.
Have an issue with being, I guess we're considered jury of paying something. It just seems like there's I don't know what. If the judge would like to, maybe.
I think that could be a bad precedent myself to start down that path. I would not be in favor of doing it because of precedent setting.
What do we need? Do we need a motion for our? How do we proceed?
Well, you would take what was distributed, the state's proposed findings of fact, and that would be the starting point to go through and see which ones you're going to accept and which ones you're going to not accept, and take it from there. Then you could add in another fact of your own, another finding saying that.
Can we just take the first proposed findings of fact and accept the proposed findings of facts on 1 through 5?
Vote on each of them?
Do we have to do it individually, or can we just vote on all 5?
I think whenever we've done these, no, if you're not changing them, yes, you can do it on all 5. Yeah.
I will make a motion that we accept the proposed findings of facts numbered 1 through 5.
I would second that.
Motion is second. Any discussion? All in favor say aye.
Aye.
Any opposed? Now, do we need to
Propose anew.
propose conclusions of law? Do we need to accept those as actual conclusions of law?
Yes, or modify them, or not accept them.
There's no penalty assessed here, right? This is just the conclusion of the law that backed up the statements.
I'll make the motion that we accept the proposed conclusions of law as presented in items 1, 2, and 3, and each subsection underneath.
Second.
Got a motion is second. Is there any discussion? All in favor say aye.
Aye.
Any opposed? Now then, do we need to have a separate motion with regard to
assess the penalty, right?
yes,
So I see that you don't have the assessment of the penalty part in here. Did you? And you didn't want to put that in. You wanted them to discuss that.
Yes, Your Honor.
So okay. So I mean, you know how we've seen.
Now you
this
need a
before.
motion as to, do we have to actually, I guess that all acknowledged that we agreed there was a violation.
Correct.
Okay.
Right.
So now we are down to
just the disciplinary phase, and then we had thrown around adding a finding in there that there's that Ms. Buchanan will sign off, understanding that she can't make the representation that kind of brought this whole issue. And I think that would be better for one of you to add the language in there. To
Can we
whatever
do
you think.
that?
Yes.
We can add that, have that letter?
Yes, you can add another finding.
Or a finding, yeah, okay.
Do you want to propose that now?
Sure.
Okay.
We would phrase it as Ms. Buchanan signs, will sign an attestation agreeing that she understands the limitations of a non-licensee, and then we would draft an affidavit for Ms. Buchanan to sign, and we will keep that in our file.
Right.
In legal.
Need a motion for that, or?
Yes.
Can I make a motion to?
Second.
Do what she said?
So the motion is to accept the suggestion of Ms. Page as an additional finding.
I will second that motion.
Okay, we've got a motion and a second.
Can I discuss that for a second?
Sure.
Would that statement also include the wording you were talking about? Because you cannot even put in your title or your business the word accountant or accounting, and so many people don't understand that. So
Right.
my fear would be that she gets through this and then
Missteps
really,
again.
yes,
Yeah.
missteps again.
And that's what I was saying. I think we have that verbiage pretty well outlined that would be easy to put in that finding.
Okay. Okay. All right.
Okay, any further discussion of the motion? All in favor say aye.
Aye.
Opposed? Okay, motion carries. No.
Well, do you need a statement saying that the board is finding that
We have not finished the
discipline
penalty
is
phase,
have we?
appropriate? No discipline.
We have not finished
We're
the
still-
penalty.
Okay, go ahead.
So that was one aspect, right? We have not addressed any fines or court fees.
Correct.
I would
I'm,
move.
I'm wondering what the, I mean, if we, I don't know if this is possible, you all tell me, if you assess the fine but waived it on condition of signing that, a test document.
I just assume not assess a fine
I mean, I would, yeah.
instead of making it conditional. Well, I don't know. Maybe you do
I
need
like
it to be
that idea
conditional, because
better.
then why would you sign the document? Do you have
We
to sign the
have-
document?
I mean, is that doable to do something like that?
I think we can
It
waive
is,
a
though.
penalty for that.
I think
But no.
she's probably right, because if she decides she doesn't want to sign this document, right?
And she can pay the fine.
When Ms. Page estimated the court costs at between 5 and 6, that was actually, even before she said it, that was my estimate too, of just from seeing other ones like this. I mean, we started this at 10 and we are almost finished this, so there's not going to be a lot of additional costs on this. So, but as far as that going, I mean, APD is still going to submit a bill, and that's not something I believe I can even change. Right. So
We could assess court costs not to exceed $500 or $600, correct?
safe on that, but because that's where I think it's going to come to, unless of course there's.
But we could cap. In other words, we don't have to charge her the full amount of the court costs, so we could assess any number.
The longer we deliberate this, the higher the bill's going to be. So let's
this is a $50 conversation.
Yes.
I go back to the extenuating circumstances point because we have decided not to assess penalties sometimes because of extenuating circumstances, and I think there were some here. And then also we've said, perhaps those extenuating circumstances resulted in this hearing coming to this point, and I'm sympathetic to the idea that, we had some costs, but I would emphasize extenuating circumstances.
One thing, and I'm not licensed, but I would think as this board, we represent all licensees, or you all do. And I got to believe the compassion that is here today would pretty much be the majority. And the easiest way to absorb the court cost is with money from our budget that licensees have paid. And it's such a minuscule amount per licensee. I got to believe the majority would say there are extenuating circumstances, and I think everyone would agree that it should have never gotten to this point, and we wouldn't have had any cost. But I think we could, as you represent those people, waive the fine, the court cost. But there has to be a guilty plea. I mean, there's no doubt about that. And the letter does.
So I go back to our original, what we just passed, just for clarification here. Do we need to put a penalty of $1,000 or signature of that affidavit? Because what happens if she chooses not to sign the affidavit?
At this point, there is not direct authority in your statute or rules to require it. So if it were to be, say this case were appealed to Chancery Court, the Chancellor is not going to enforce it. So this is really a good faith move.
Oh, so if we do require it in lieu and waive the fine or cost all of that as a result of signing that, is that possible to do?
It is possible, but as Ms.
Or legal to do.
So we can't require it, but we could charge a $1,000 penalty.
If it's not done.
But if she wants to sign it, then we waive the penalty.
Yes.
Is that legitimate?
That's what I'm asking.
I don't think there was any question that Ms. Buchanan was going to sign it, because I think you basically agreed that going forward, you're not going to.
Would it be easier if I just amended my motion just to include either pay the fine or sign the document we talked about?
I mean,
I don't see anything making that illegal. I think you can.
I would just do that.
And that way, if that's the case,
let's do that.
Can I do that right now?
Go ahead, let's hear what you're proposing.
Do that.
I'm going to do that. I want to amend my motion to include issuance of a $1,000 civil penalty, but with the option for the penalty to be waived if Ms. Buchanan signs the letter, which we described, the affidavit, which we described earlier.
Technically, I don't think we can amend a motion that's passed. We passed.
Well, then I'll
it,
make
so
a
you
new
can ask
motion
for
to do
reconsideration.
exactly what I just said.
Okay.
I think it's creative and it works. I see what you're saying about Chancery, but there's no reason this should end up in Chancery.
I agree.
So
I second that.
Okay.
Then. That amendment.
Where are we? And I've lost track here.
Are you keeping this?
We are.
Record?
So
okay. Then you're
policy.
Okay. Policy.
Unless they don't want to do anything with costs, so just leaving that out.
Right. So you're down to your policy statement.
Down to costs.
Down to costs.
I would be opposed to paying out of pocket, that kind of thing, because I believe that could set a precedent that we may not want to deal with.
But we have made, we've
Wait till we assess
taxed
the
the cost to the
$10,000
state in the past. We've done that.
I think we can.
Right. So I think
But
you
I
can
think
just
the
say
board
the
can-
Yeah,
cost of this
I mean, as
proceeding
a
are taxed to
board,
the
I don't
state.
think that's a
Yeah.
path we
Yeah.
want to go down.
I make.
I personally think I see both sides. I'm sympathetic to the whole thing, but I'm also looking at my duty as a board member, and I think had there been better communication, we would have avoided this. There's an admission of guilt. I'm trying to be sympathetic and as far as avoiding a penalty. I'm not trying to just pile on, but I do think there was a wrongdoing committed here, and I don't think it's fair to our membership to float this bill. And so that's my reason. I guess I can make a motion and it can either die, but my motion would be is we assess the court fees not to exceed $500 with the ability to pay this, have it set up a payment plan. I don't know what terms we can offer. I would yield to our executive director to negotiate that in a fair manner that's not going to be detrimental to Ms. Buchanan's financial well-being.
I guess my other concern is I don't understand why.
We got a motion. Do we have a second to that motion?
I'll second that motion.
Okay, now we've got a motion, a second.
Now
Janet,
it's
let's
I can discuss. I don't understand why we have to do these hearings to find facts versus somehow we're allowed to have enough information ahead of time so that we can avoid this kind of process. I don't understand what in our process needs to change.
The problem is
There
we
was
didn't
no
have a
response.
response.
I know, but is there something that, because, this is to me like the second time we've done these long hearings.
Well, we were
This is
given
not
the
long.
option. We were given an option of delegating.
Well, no, this isn't, yeah. But it's
I've
like
been
it's
through long.
something that could
One
be avoided.
person
I don't,
talking at a time here. Go ahead, Janet.
I guess, and we don't have to deal with this here right now, but I guess I don't understand why we can't get more information about this stuff rather than going through these hearings to get it.
Janet, I
And-
would say there is due process, and she deserves to be heard, even though she did not respond. And so,
right, but
we
isn't there
can't.
another path we could take other than if she doesn't respond?
We were given the option.
Then can you bring that to the board to say, well, this
We had a
person-
consent order that was never right, or did we had a consent?
we were
It was in the
given
legal
the-
report.
Members of the
no
board,
response.
just to go back through the process, we had received this case as a complaint. We presented the evidence we had without a response to you. A penalty was voted on by this board. It was rejected. At that point, we could have brought it back to you.
How was it rejected?
Because it was not signed and accepted. So that's the settlement option. At that time,
So there was no response to that?
There was no response.
And that was taken as a rejection?
There's no
Okay.
response to the mail, and then eventually it comes to a point where we have to take this to you, and we are bound by what you all assess in the legal report meeting. So at the end of the day, we are here just to carry out your will. And so if there's a penalty assessed and
It
it
says
wasn't
another
accepted,
thing. It says
we're
by
here.
consent or by formal hearing.
That's right. So this is the formal hearing portion. So there's we obviously we also love to settle. This is a lot of work. So we do the best that we can, but that's not always possible.
We were given the option as a board last meeting or maybe 2 meetings ago to delegate the authority to settle this particular situation by staff and legal, and we chose to not delegate that. So we're here kind of our own fault in this case. Because we were
maybe,
given.
I think
maybe
we should
can
have-
correct ourselves.
Yeah, and because of that,
Or look at how we handle that.
But
we
not
should
really.
probably
Had she
absorb that.
responded, we would not have been here to start with.
I think that's a good argument.
that's
I think that's a
excellent.
good argument for our absorbing the court
Yeah,
costs.
I
as
do
well.
too.
Yeah.
We should be a little more careful about that sort of thing as a board. So we have a motion. Are we going to vote on that?
Well, and
I'd like to.
I think we've got a motion, a second. I think we've got to vote.
Well, let's repeat. We had two motions. One was your
All right, my
reconsideration.
motion was to assess the court costs not to exceed $500, give our executive director the ability to negotiate with Ms. Buchanan a payment plan that would not be detrimental to her financial condition. And that's my motion.
I second that motion.
And do we need to do a roll call vote or?
Probably so on this one. That'd probably be a good idea. So, when do you want to do a roll call or somebody?
No.
No.
Aye.
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 No.
Aye.
Aye.
No.
I think it's.
What was the total, Wendy?
6 ayes, 4 noes,
Okay.
total of 10 votes. The ayes have it.
So that finishes the penalty phase, correct? Where do we need to go next?
The statement, the policy reason.
Okay, what all needs to be included in that? I'm going to take a stab at it, but I would also say if anybody else here feels they want to do that, they're welcome to do it. But go.
Everyone always says to protect the health and welfare of the citizens of Tennessee. That's what they almost always are. So you can think of something else that needs to be in. Okay.
Just that short and simple.
I think so.
All right. Well, I've got that written down here. So maybe I won't mess it up.
Mr. Chairman, I think if I got a moment just to say something, Trey brought up a really good point a few minutes ago. As everybody knows, this is an open hearing, and we have an audience since we can't really pay the fine ourselves. We have an audience sitting out there, and I would encourage somebody to consider going to a developing or opening up a GoFundMe page and to help Ms. Buchanan pay these court costs. And I hope that somebody's out there listening to us to do that, since we can't do it ourselves, and to help her out, considering her needs.
Okay. Our policy statement. The Tennessee State Board of Accountancy is charged with a duty to regulate the practice of accountancy in the state of Tennessee and to protect the public of this state. I would say, based on the findings of fact, as we have approved here today, and the conclusions of law, that we believe the penalties assessed are appropriate in view of those findings of fact and conclusions of law, does protect the public interest of the state of Tennessee.
Oh, we have the affidavit, so we'll have that signed as well.
Okay, then I think you've finished everything, and I believe that concludes the hearing today in the matter of Vernola Buchanan. And I'd like to thank all the board members for your time. We're adjourned. Thank you. We marked 3 exhibits, which I'll.
Yeah, we're going to take a break. We've got lunch, and I think. Do you want to try to get through this agenda so that if somebody chooses to just take their lunch with them, they can do that, or do you want to break for lunch and then come back for a?
Yeah, let's keep.
All right. It seems like the consensus is to keep going. But let's take a 5-minute break, just 5 minutes, and then come back and we'll.
Hey, I got more.
That's what I thought. I saw that happen earlier, and I was like, so we need him all the time.
Yeah, I was playing. It's almost halfway. It's close. Yeah, give us
Very much.
Such a Let's go ahead and finish the formal meeting, and then we can stay and chat with each other and enjoy our lunch or whatever. But we're down to the agenda item, old business. Is there any old business that we need to talk about? I am not aware of any.
I have one thing that was on there in the minutes. I don't know if that's under old business.
In the prior minutes?
Yeah. it was in
I
the-
have not done that, so I can. Okay,
Statistics of what type?
statistic. What exactly are we looking for?
Well, like who's doing? I mean, what other states are doing, and how?
Well,
feasible-
everybody's at 150
How
hours.
feasible would it be to potentially go back to 120, or just adjust? Long, deep discussion about this at all, but I think my issue is I think that we're looking at it wrong and trying to grab up other majors, CBAs, or other areas of study is not the place. It's we need to improve the size of the pool for ourselves, and I really think the 150 is just, I don't understand the logic behind it, because the extra 30 hours for me did not make me any better or worse of an accountant. And that's where I'm coming at with this. And I think that's something we need to look at. Nobody agrees, and that's fine.
Well, you know, my concern, it's that the extra 30 hours have become undefined, because in most states, I think most, but many states, including ours, you can now sit for the exam pretty much right after you finish your undergraduate. So the pressure's on the schools to put the accounting in the undergraduate, so then what happens to the extra 30 hours? And I've heard just some wild tales about what people are taking, because now they do try to cram the accounting back down below, or they give credit for CPA review courses, which used to not grant credit, and so they're paying tuition, and we're calling it a master's degree, and that just really bothers me. So that it needs to be defined, and data analytics may be the way they define it, but
Yeah.
I'm with you. We need to make sure we want all accountants to have that same level of training, if that's what we're going to do.
I mean, sociology was a great course, but it did not help me a bit in my day-to-day. Psychology would.
Well, it's hard to say what's the extra. When the 150-hour white paper was written by the big, however many there were back then, it was for the purpose of pulling the technical training education to the 5th year, so that the undergraduate had general education, liberal arts, writing, complex thinking. They talked about that. General business, basic accounting, and then the more sophisticated was at the technical. And the idea was, let's not crowd those things out with the technical training. And now we've gone the other direction, but because the market's demanding it. I'm not saying it's wrong, but the market is saying we really need these accountants. We really need the heavy accounting, and so it's moved the other direction. So nobody knows what the extra 30 hours are for.
Should be grammar, too. That should be one mandatory.
Absolutely.
I just wonder, though, if it's how much change do we want to affect? Okay, and do you have to be a board member in a state board to be a member of NASBA's committees? Are the only people they accept, are they?
Well,
Or can you be a practitioner that the society puts up for it? I'm
so
curious.
this think tank, or I don't know what they have a name for it, and I just can't remember what it is that they're putting together, is not just of state board members.
Is it another Pathways Commission?
It is basically
No,
that.
I meant that.
I mean,
that's
that-
what they've called it in the past, is all I'm saying. I think there've been 2, maybe.
Oh, it starts with a C, I believe.
Oh.
But this is as a result of the alternate pathway. And so I think the result of the alternate pathway was nobody wants an alternate pathway, but everyone agrees that the issue needs to be discussed. And we're at a point where we do need to figure out what the next 5-10 years looks like. And
How do we grow our profession? And that's kind of the big question, right?
And it will.
And that's what everybody's asking the question of. And my question is, if we feel strongly as a board that the 150-hour requirement is detrimental to people entering our profession, what are we willing to do about that? Because we make the laws and the rules.
No, we
We
enforce,
do.
we enforce the laws and the rules.
Well, but we recommend those requirements. The legislature just didn't come up with 150 hours. I mean, they did that at our request. And my question would be, to Casey's point earlier, I mean, getting any state to get on the same page is difficult. But I would tell you this, if you don't try to push the agenda, it sure as hell is never going to change. I mean, it will never change because everybody will think it's too hard, and we've already been down this road, or we've already done this. My thought last meeting was, you know, if we had 10 other states that felt like we did, and we had a common letter to NASBA that said, we feel like this is an initiative that needs to be undertaken by NASBA to affect changes within the states. Whether or not they're successful or not, you know, I don't know if they can change these minds of these other states. But I would tell you that from the private side of the industry, and probably from the public side, they're willing to lower the requirements to have a bigger population of students to pull from. Otherwise, to me, the CPA designation is going to continually fade at this point if we're not careful, based on what's happening with technology, who's going to enter the market. We got a tough battle ahead of us, and all we've done is managed to put roadblocks in front of our students.
I fully agree with that, and I think that the bottom line is if the person can pass the test, they can pass the test. I mean, I don't think we should have a huge amount of roadblocks to keep people from attempting that. I personally think that fifth year is... I never thought that was a good idea. And I know that universities make a lot of money off that, but to me, I think what's important is getting more people certified and keeping the profession alive. And I don't think a fifth year is required to do that. If a person can take the test and they've got a bachelor's degree and they pass it, they pass it. I mean,
and it's cost prohibitive. I mean, people don't realize what it costs to get a master's degree. And I know KPMG, I've talking to Greg Barnes in Memphis, I mean, they're paying for students' master's degree that they identify. People have to apply, and they grant certain students authority to do that, but they are paying the 10 universities that they've decided are their premier universities. They're paying for those kids to go to school to those schools. I don't know. I just feel like we're at a point where I don't know what we're going to do as a profession, because I think we've put these roadblocks in place, and now can you get a state like California or whoever to say, hey, no, I'm never letting go of that requirement. I don't know. And then if you do that, then you have no reciprocity. I mean, that's where we stand. I get it. But the conversation needs to be had. And it would be nice if we could have strength in numbers to start the conversation.
I found something from November 2017 where they talked about new pathway to CPAs and a CPA pathway task force to consider how, for example, requirements might be changed to give engineers the accounting language they need to fit into the business education model, and pointed out that the CPA exam needed to keep pace. I don't know if that's the same task force you're talking about, but it's all tied in together, right? So
So that one is the one that has been basically the feedback.
Looking at alternative.
The feedback has been, we
Negative.
don't like that idea.
Right. But it's really tied together.
But
because
we
we're
agree-
defining what
we
you
agree-
need to do to be a CPA.
Right,
so.
but we agree there are issues and it needs to be discussed. So this new group has been created that it will just start their meetings here very soon, and they expect it'll take a good 6 to 8 months before they have anything. I guess I feel like we need a consensus as a board. I don't know if a letter to Ken Bishop copying the society that this is something this board wants to encourage groups to look into. I'm not sure what else we can.
Could reach out to other state board executive directors, right?
Yes, but then I'm not sure that from my discussions that I already have, this is not something that has been discussed at board meetings. And I would venture to say that a lot of boards don't feel like they probably have all the information they need to really know if they want to go in that direction or not.
This is like the adage, of Ben Franklin, and we can either all hang together or we're going to hang separately.
Right.
And so I don't think that Tennessee as a board should stand up and basically make a decision that we're going to jettison a 150-hour requirement because we would be immediately ostracized. And
I'm not at all sure that that's what I would support. It just bothers me that we don't have substance to it right now.
My view
Well,
would
I
be,
think you're saying the board members are saying two different things.
That's exactly
here.
right. That's what
and
I'm
so,
saying.
If we're going to do anything, I think we need some sort of consensus to do something. So I'm hearing over here. I'm
role to encourage the discussion with either through NASBA, I guess, to
I don't know where else you would do
explore this option because again, I truly feel that.
But you two are saying.
I can tell you, in my business,
suggesting
the
a
fifth
120.
year has zero value to
None.
what they do for me
Master's
in their
means nothing.
jobs. And I think it has no value to them passing the CPA.
but the requirement is not for a master's degree, it's for 150
That's
hours.
correct.
There are a number of undergraduate institutions, and what I did was I got my 150 hours with an undergraduate degree, and I did it in 8 semesters.
And do you train your employees when they come to work for you?
Yeah.
I mean,
our
you
firm
have to
does.
teach them what to do all over again, right?
Well, not necessarily all over from the beginning, but,
mean-
we teach them the particular methodologies
Right.
and tools that we
They
use
don't know
like
the
every other firm
practicality
does.
of what they're doing.
I mean, 90% of what I learned was in practice.
Mhm.
Just a random guess, but I mean, they're not. There's a 4-year degree student versus a 5 years. There's no difference, in my opinion.
I really think that right now, and I disagree in one way in that more education is needed, and I support the 150, but I also agree that it needs to be more refined. There's data analytics that we're now asking accountants to do. You've got to have this background of the core accounting, plus you've got to have something else where we're going with the industry. And I really do think that once this commission, for lack of a better word, gets together and this task force, once they get together and talk, that we may get some information out of that. And I really do think that that the 150 hours, it may not be something that can apply to you, but when they come to your firm, but yet they're educated to the point that they can perform the duties. They understand.
And you've imposed another $10,000 to $15,000 worth of tuition cost on these individuals.
We could set up GoFundMe accounts to cover that extra master's degree if you want.
My point is, one, you got to do a cost-benefit analysis, and that's what I'm really wanting NASBA to do. What is the cost-benefit of having a fifth-year degree?
I would disagree that there's not a difference in a 4-year and a 5-year student the way the current system is, because all the universities have now moved the upper level courses to that 5th year. So if you hire a person now with just a 4-year degree, they don't even have the upper level courses taken yet.
See, there's a movement now to reverse that.
Yeah, I'm saying under the current system, there's
Right,
a big
I
difference.
think that's right.
There's a big difference
that's
in a
right.
4-year and a 5-year student.
Or they're
But
not
they
even
don't
ready
do
for
it. They don't do the upper level until they do their masters.
Exactly.
We have consolidations, corporate tax, governmental accounting, business law, all that's in our graduate
But a
year.
person with a bachelor's degree now is lesser than a person back in the day with a bachelor's degree.
Exactly.
Because this 150 pushed those
Yeah.
upper
Yes,
courses
and they will
until
tell
the top.
you- they will
and
tell
maybe
you-
they expanded the undergraduate, so some schools put in an extra cost course or something. But
They will tell you at the University of Tennessee in the accounting program, if you hire one of our 4-year BS degree students, buyer beware, because they don't have those upper level courses.
And I
yet.
get concerned when I hear some students saying, I'm just going to get the extra hours myself, and I'll say, but you'll be sort of teaching yourself consolidations and corporate
I'm
tax and
not
things like
saying
that.
you couldn't push those back down into the 4th year, but right now, if you're hiring BS degrees, they're not coming to you with a full, they're not hitting on all 8.
I think that's one of my concerns is we don't really have a model for what the 5 years look like. And I'm not opposed to what you're asking for, except what I'd like to see is a study of what our profession thinks should be the model. Not that all schools have to adopt it, but right now, we have these laws in place and we're not sure why, and we're not sure how.
Well, and we have an archaic test that all classes are driven towards passing. The tail is wagging the dog at this point.
But our
And
pass
so-
rate's gone down. Even though our kids are more educated now, the pass rate's gone down. So, I mean,
And I mean, I'm for going back to the 4-year, obviously, but now that people have been required to take that 5th year, getting the mass to go back to what it was before, I mean, I think that's.
I'm not
Well, here's the problem. Here's what you're going to end up with. You're going to end up with fewer accounting personnel. I mean, that's where we're headed. So,
Wendy, I'm not here to debate the philosophy of this. I think it's in my opinion, it's responsible of us, the board, to try to be proactive in this. And if we can help drive some efforts towards improving the pool of CPA candidates we've done a good job. And if other states say nope, not going to do it, then I don't think we're going to hang alone or want to go that route.
I don't know why the AICPA isn't pushing those.
They should be.
Or the Tennessee Society, or whoever.
I just think that an easier road was taken to say, well, let's just we'll just add more people to take these extra things. I mean, let's look at it the other way.
We've been shutting off the 150-hour requirement through the back door in ways ever since it's been instituted. So it was instituted. We realized that the numbers dropped drastically after Florida and some others instituted. So yes, so the pass rate magically went up, and now we're doing other things. And so I want us to be forthright. I think it's unethical to do it the way we're doing it.
It sounds like we've destroyed the bachelor's degree of accounting. And that's embarrassing if that's the case. That's really embarrassing, and whoever the people that created this rule should be embarrassed about it, because it's been counterproductive. And it's been an additional financial burden on our kids, on the students. Anyway, I'm sorry. I don't want to get off on an hour-long deal, but I think, what can we do? I'm looking for
Let
suggestions.
me make just a couple comments here. These are really good comments to hear from everybody, and I can assure you that this topic has come up before at NASBA, but it's coming up, I know, in this annual meeting. I visited with the Kentucky board. It was in June or July, and they had a retreat after we visited with them, and I know that one of the things that they came back from the retreat with was the idea of going back to the 120-hour requirement. Well, the NASBA has a board member that is or a slot that is for a member that represents all the state boards. In other words, Wendy Garvin could serve on in that role. Last year it was an individual from Oklahoma. This year it is the executive director, I believe, from Kentucky, and he's a pretty impressive guy. I mean, he's got a law degree, tons of experience. He's been. I know it will bring that up in the board meeting, and it will come up again. I think we need to bring it up in this regional breakout session, Wendy, and just share with the other states some of the comments we've heard here today. And there may be a number of other states feeling that way. I mean, I've heard what you said, Trey, and I hear that. I mean, I think that's part of the reason Kentucky's taken the position they have. But I also agree with what Andy said. I mean, I think we got to let this task force that's been appointed, that's got a broad representation on it, see what they come up with, and how they define that extra 30 hours or the degree requirements. And I mean, we could do what we want to do, but I think we just need to keep aware of the.
Now, my only point is I want to drive NASBA on initiatives. I mean, if a board feels strongly enough about initiatives, how are we driving that process? That's my only point here.
And I think, go ahead.
I mean, somebody may come from Oklahoma and say, hey, I want to talk about this. Well, that's one thing, because Yeah, I can see people saying, yeah, that's a good idea. That's great. Well, we need to look at that. But I mean, is that really driving policy, or does it mean more when 10 boards of accountancies sign a joint letter to NASBA that says, we feel like this is a initiative that NASBA needs to take on? Because NASBA's there to represent us, are they not?
Yeah, and I think that's even more reason why we need, and I think, I don't know how we communicate this to the powers that be, but we have great discussions on this board. And if we carry those forward to those annual meetings or Eastern Regionals or Western Regionals or whatever, and we have more of our board involved in everything, as we've worked really hard to do the last couple of years. And that's where we can affect change. And without the ability, because right now we're limited to the number of people that can go to these events, I think that we need to take a hard look at that and see what we can do to make a change in that, so we can go and present these thoughts at these meetings.
I'm just going to make a plea to the camera if anybody's out. I'm kidding.
So here. So what would be a joint? We want consensus of the board to move in a particular direction, right? So we can't argue for 2 members that we want this, and
I understand.
And another 2 members want this. So if we can come up with maybe some sort of general thought that you would like Casey, Andy, and I to push, whether it's a review of the 150 hours, in more detail as part of this initiative, we can attempt to do that and maybe find an appropriate time to send some sort of communication.
the first step, I guess, to be simple, is just to see if there's other boards out there that have any similar interest. I mean, I don't want to go through a whole bunch of exercises if we're going to be the ones they're going to say, way to go, Tennessee, you wasted all of our time and nobody else wanted to do it. But just float these general ideas, and I don't know if, I don't know how to get that out. Maybe as I assume they've got publications or they've got requests for feedback on this topic of exploring the possibility of altering or the 150, whether it means specifying the extra 30 hours or cutting it back to 120. I mean, there's really no, I don't have a specific agenda in mind. It's just I see a problem, and I see that as a potential solution to the problem. Let's explore it. Let's see if other people are thinking that way. If they're not, then I'll be quiet. I mean,
I think the regional meeting is a regional breakout session is a good time to just, and you could even say some of our board members feel this way. You don't have to say it's an official board position, but
even say there's some very strong sentiment on our board. You don't have to say
the
majority.
150-hour requirement.
Yeah.
And just see where that conversation goes.
But really, the broader question is exactly what this task force, from what you say, is examining, which is let's look at the required education to become a CPA, define what it should be, and then decide how it should be accomplished. So what we're asking for is justify anything you require. And so that does include, in my opinion, the 150. It also includes everything else about it. I mean, you look at the crazy requirements that some states have. I shouldn't say crazy. The very specific requirements. Our profession needs to define what's really needed and think of it as asking people to dip into their pockets and pay for this, because that's what it comes down to. So I just think we're asking, it's the old zero-based budgeting. We're saying don't assume anything. Go back to the square one and do it. And frankly, I think it'd be great, if you're interested, find the old white paper where this whole 150 hours was defined, and they tell how it should be approached. The
thing I can assure you is it's not going to get more stringent at the states. I would really find that hard to believe at this point.
Well, we're not in a political environment for that either.
You're not, and you're also not in one where the profession lends itself to putting another roadblock in front of students.
Yeah. Well, and Pam could address this better than any of us, but, if we change this rule, it's going to have to be it's effective 3 years from now or something, because the universities have made a major shift to accommodate the 150 hours, and now to to tell them, well,
But I think-
we're not
I
gonna
think
do
you
that
don't-
anymore.
Get that. Tell that student that had to do this.
I think you don't
last year.
realize. I don't think you don't realize how much we felt that when the boards
Yes.
moved just recently to say, oh, well, now you can take your CPA exam right after the undergraduate. Because now my students in their graduate classes are thinking anything that's not CPA exam don't bother me with. So the higher order thinking, the writing, presentations, don't bother me with that. Is it on the CPA exam? And so maybe we're saying as a profession that is what we want, but you have to think of all these repercussions for schools because all the schools had gone toward pulling the upper level courses to the graduate year. And now we're saying, never mind,
But you know what
they
you
can
could
start
do?
taking it right away.
And this is where I struggle. I'm on the advisory board of the University of Memphis because I feel like I'm driving this technology approach to being involved in the curriculum. But what it's going to do is it's going to make the schools have to compete for people to take those programs because they could potentially be teaching skill sets
That's right.
that
And
are
that's
not
where the data
necessarily
analytics
accounting
has come in.
required classes.
That's right, and that's what's happening. That's where it's going. And so, you know, I think it's been interesting to me to watch it because I had already written a paper that talked about the vacuum of the extra 30 hours, and then here came data analytics filling it. And I thought, well, of course it did. It was a vacuum. We have created a vacuum of 30 hours, it seems.
But I'm sitting here paying a premium for a master's student who I perceive really no difference from the undergrad student.
Of course, right now.
Because we bring interns in now when they're juniors or
Right
whenever
now,
they are.
I think you're paying the same for a fourth year or a fifth
Seriously.
year because most people, you know, you're going to require them to sit for CPA exam. So I don't know what the market says about that. I don't know what the price is, but somebody does pay for it.
So I
So
don't
you're
know
clear
where we
as mud
landed.
now.
So do exactly what all that stuff we said.
Well, it's definitely.
If you're telling me there's a task force that's
It's
legitimately
a little
looking at
broader
all
than
this
what, I mean, it's
issues.
broader than what you're talking about, meaning it's about the profession in general. Where are we going? How are we going to get there? And I'm sure a piece of that includes, are we doing the right thing with 150 hours? How deeply they're going to go
Right.
into that, I don't know. I don't even know who's on this group.
Well, here's my
yet.
problem. I really don't even know what the major initiatives are for NASBA at this point. Like, I have no idea what their major pushes are as far as the profession goes in today's day and age. I just don't know because I don't see a publication that tells me these are our 3 initiatives or these are our 5 initiatives. This is what we're trying to address because I don't know. I mean, are they making headway or are they not making headway? Are they?
Those are the things they
Honestly,
cover.
to respond to that, I mean, I think every board member here ought to make time in their schedule to go to an NASBA meeting. They can only help the states that won't help. You know,
I want help. I'm asking for it.
And they are very, very willing to do that. I mean, very responsive. And I just wish, I mean, I made the comment, I waited 7 years to go to my first NASBA meeting. And I tell you why. I didn't know what NASBA did and I didn't really too much care. You know? And I've been to enough meetings like that over my career that traveling to Phoenix or New York or Miami or somewhere just didn't. But I came away from that first NASBA meeting feeling much different than I did going in. And I've encouraged Andy as a new member. I know, well, you've been involved.
We try to go, but we're not able to go.
How do we push this? How do we ask them for help with this area? Because we're asking. That's what I'm doing.
Well, it sounds like we got a task force. My problem is we don't
I think
know.
they're plugged in, and I think it will come out in these breakout session discussions because we'll have just in our group, and they've got a group for every area of the country. But you know, we've got Kentucky, Tennessee,
Georgia.
Florida, Alabama, Georgia, Mississippi.
And I'm appreciative. I really am. And what I would like to know, and shame on me for not having gone to a meeting, but at the same time, what are the major initiatives?
They do have a strategic plan, which they will unveil next week, so I will be sure to share that with you.
Because maybe some of these things that we're asking are already addressed, but we just don't know.
Yeah,
They are addressed.
I don't know why they're not here talking to us about
They are
those.
addressed at these meetings, but like Judy and I just experienced recently. We were going to the meeting, but we can't go because the state C&I has this rule that only 4 people can go to each meeting. So
Start a GoFundMe account for you. And
I was going to make a plea.
We're doing an official plea
But
to be
there's
able to
cost
go
of
to
a
the
cup of
meetings.
coffee for 35 cents. You can sponsor.
So even if everybody here wanted to go, it would take 6 years for everybody to get a turn.
Yeah, because the chairman has to go, Wendy has to go, and then Andy's the southeast.
So one person is only
one person extra can
So
go.
I don't agree that chairman has to go every year. I mean,
Oh, you don't? Okay.
I've been going as role as a board member at NASBA, so I'm already.
Yeah.
The state, I guess, doesn't. They approve a budget with
Well,
travel
it's-
included, but. The point is, I don't think you just have to go because you're chairman. I think we need to rotate that around and out of the. I think Wendy's the one person that needs to go to every meeting. She can be the common denominator, but I think we could have 3 other people.
But with Andy on the board, he needs to go.
Well, that'll probably be true. So that'll leave 2 open slots each time. But I just
Maybe if we could share the strategic plan at the next meeting, that may absolve any of these questions that we're bringing.
Well, I will tell you that I was on that task force that revised the strategic plan, and it does not go into this kind of depth. So I can pretty much tell you it's not there in that.
Know what the major initiatives are.
So their strategic plan is broken down into like 10 different areas, from operational excellence to. Do you have a copy of it? Right. So, but would you agree by glancing at that?
I wouldn't. I mean, they have the CPA pipeline. I was just looking at it, and that because they had readouts at meetings before about the CPA pipeline and what's creating shortages or ways to increase the CPA pipeline. But yeah, it's very
vague in general.
Yeah. Now, there is one on here, emerging issues, monitoring development and education that may impact the quality of candidates for the CPA license.
Quantity, too.
Monitoring professional standards. So there's, it may relate, but yeah, it doesn't really say what detail they would go into.
I can tell you what what NASBA looks for is like at these breakout sessions. They have a scribe there that takes notes, and by state, we'll have an opportunity. They'll ask us to, what are the things Tennessee's wrestling with, and come out of this meeting, CPE and how to lower our audits and so forth is one thing we'll bring up. I mean, we'll talk about this 120.
Submit your stats.
Yeah.
I will.
I mean, to me, that's important for them to know that.
Yeah.
That's a reflection of the entire profession.
So we'll have an opportunity to say what, some of the things we've talked about here today, and then they'll go to Alabama and they'll do the same thing, and then all of a sudden you get a dialogue going, and that's where you and NASBA's taking notes from that so they can figure out what are the real common issues out there. The other thing is through these focus questions, and one of my roles as regional director is you got to call and remind the states because to send those in, because last report I got, we only had 3 of the 8 jurisdictions that are in my region that had responded, so I had to pick up the phone and call them and remind them, oh yeah, could you send me another copy? NASBA takes those and summarizes them, and this is an area probably based on the breakout session this time that I will bet you'll be in future focus questions. What does your board have a position or concerns about the 120, 150 hour requirement? So it just takes a while to build consensus, but I think there's a mechanism there to get some of the concerns I've heard here today to get those major agenda at NASBA. I mean, you talk about their initiatives. I mean, I think the big one before this
the
CPE thing was that gateway and the revision of that, which they spent millions of dollars on that, getting it programmed and work.
What is that?
Well, Wendy could tell you more than I can, but it's what
That's where they house all the candidate data. So when somebody applies to take the exam, and we contract with them, I mean, that's their entire platform that they manage that off of. And so they had to upgrade that, and that was significant.
I'm hearing you right, then the mechanism to do it is you take our message to those discussions. I trust you.
And you'd do a better job than I would.
I'll definitely. I'm going to set up a GoFundMe, and whoever does it the best will be the beneficiary of it.
We will all make comments.
Okay.
Yeah.
Yeah. And it'll pay for Larry's trip too to go.
Mine too.
Sure, whatever. Everybody.
We might call Larry and talk to him while we're out there.
You hold the speaker up while we talk.
Yeah.
Chairman, are we adjourned?
You can FaceTime now. You can just be
Yeah.
present without being present.
Yeah. Mr. Chairman, are we adjourned?
Well, no, we.
That's
Is
just old
there,
business.
I need to ask: is there any other old business? I didn't know we had all of this, but it's been good comments, and we'll take those to our meeting. So, any other old business? Is there any new business?
We want to talk about NASBA again?
So can we cut the hours to 60?
I just don't want y'all to think that I've gone out and drunk a bunch of Kool-Aid.
No.
Kool-Aid, because it's not. I just think
I saw that NASBA tattoo on your neck. I was going to ask you about it.
But
on your lower back.
I really believe that anybody would go to those meetings will come away with a changed.
I just
And I
wanted to
think it's
communicate,
important that
too,
we do
what
it.
what they're focused on.
Yeah.
That would be helpful, just so we know kind of where are they going right now.
Yeah. Right now, it's
This should be changing from year to year.
That's been appointed is one of the big initiatives. I would tell you other things going out there right now is a real. There are several organizations that are promoting deregulation of the professions.
Mm-hmm.
I mean,
This
what
is
they're
a
trying
big
to do is
thing.
knock down barriers from state to state. You know, being able to cross state lines and get gainful employment. So they're trying to eliminate. There are states that have got legislation introduced to basically eliminate some of the regulatory boards. And NASBA's tracking all that legislation. They'll have a report on that.
Do they have a position on that?
Oh yeah, they
want to stop it. Okay.
They want to stop.
I mean, they had to basically parachute into Texas a couple months ago and testify for that to help them through.
Texas was wanting to deregulate.
They had some sort of deregulation type bill that was. I think they wanted to change the makeup of board members to be a majority not CPAs. And something like that.
Look,
Don't quote me.
They just need to get California out. They just need to get California out of those states, and they'll take care of it, right? California will get them.
So, I mean, they give reports on all of that at almost every one of these major meetings. So,
Do you all get the board report?
I get that.
Okay, that's it. Read either Ken Bishop's articles in those. If you focus on anything, look at.
Last one you said, that's when that whole alternate path thing
Yeah.
came out, and what was it, that dog won't hunt? Or
Yeah. So just though, if you're going to look at anything, those are good publications, and especially his. If you can only read one thing in there, his column or the chair's column, it's one or the other that basically writes something, and so that's kind of what's at top of mind right now. And
It was amazing to me how quickly that alternative path idea came and hopefully has gone. But, you know, it was in reading that's where I saw it first. And it really does pay to read that because there are some really major ideas that come through.
Well, you know, that's an example of where NASBA listened to these breakout sessions, and I can tell you the breakout session we had where that was discussed, the NASBA representative that was presenting that thing, we had to give him a little oxygen after he got out of that meeting.
There was two articles. There was an article that said that dog won't hunt, and then one that said that dog will hunt, and so they just picked which one right the next day and got it out. Right?
No.
I'm kidding with you.
Yeah. But
You too, Ken.
they do listen, I think, to what these breakout sessions, what the states are saying, and try to. I mean, I will tell you, they were pretty rough with Dan Dustin. You know, who was
There was no
presenting
mercy.
Yeah.
No mercy in that meeting.
Dan Dustin, he's the NASBA representative that it's called the State Board Relations Committee, and He goes around and visits all the state boards on a cycle basis. Can't do it every board every year. But
Casey told me to hush that night or that afternoon. He pretty much. He pretty much.
We're not getting to go back.
Well, that's probably true. I hadn't thought about that.
I tell you, Larry and the Mississippi board alone bruised him pretty bad. I tell you. But they listened, and all of a sudden you take a different direction. Everybody kind of said, "Yeah, we need to resolve this. We don't know how to do it. Let's don't approach it from an alternate pathway. Let's do it, through looking at curriculum." And so, anyway, is there any new business? Yeah, make a motion.
I'll make a motion that we adjourn.
Second.
We've got a motion and a second. All in favor say aye. Aye. Any opposed? No. All right, thank you.
Sir, be safe.
Thank you, Jason. Safe drives. All right, see you. See y'all.
See ya.
Kevin? See you, Kevin.